Item 2.
No interference is called for in the petition under 482 CRPC, hence the same is dismissed. However, I have directed the trial court to dispose of the trial as expeditiously as possible, preferably within 3 months hence.
I want to mention, my lord.
Yes.
My lord, item 58 of my lordship's board, your lord.
Yes.
I am seeking for an adjournment that I am not prepared
Press matter after notice matter.
after notice.
Wait. The other side has to be there.
Other side,
My lord,
as because there is no such interim order, your lordship.
Whatever, but he
I am there for the opposite party, my lord.
he says that it is infructuous.
No, yeah, it has matters become infructuous. I am also of the same view. So there is no point carrying it forward.
Let's examine them. Okay,
I don't
call
mention.
it. It'll reach. Don't worry.
Belgium
Yes.
matter. I mentioned second. This is the second memo. Belgium matter.
Give it.
Another is
Reach it if possible. Yes.
Please, your lordship. My lord, CRLMC 2023. You're listed before another coordinate bench of this honorable court. Date was fixed to 14/9 of 2023 for the next hearing, but it did not get listed anymore. Now,
They're listed before some other bench. What can I do?
no, my lord, now the assignment is before this honorable court.
Give.
Grateful, grateful.
Yes.
Pardon to make a mention, my lord. Compromise matter, lordship. Kindly take a note tomorrow, lordship.
Not tomorrow. Give you a slip settlement matter. We will take it up. Take it up as quicker.
Yes, my
Maybe
lord.
next week beginning and give it.
Compromise matter.
That's right.
I have given.
Same matter you are talking about.
No, the case is fixed for commitment.
Huh?
For commitment, the case is fixed. For commitment of the case.
When?
On 31st, the case was fixed for commitment. It is a trial by the CJM. Case was committed to the sessions. Thereafter,
What is the offense?
offense 436, 395. Village dispute. Jamiru dharna kati nahi gale. This is the allegation. Matter has been.
You seek adjournment. We will hear it. What is the big?
Matter has been compromised, and there is.
Even if it is committed, I can't cause of what?
Well, earlier.
If you have settled, even if after
No, before commitment.
also we can do it.
The case is of the year 2010.
Whatever. So you give the.
Yes, I have given.
We will
1, 2, 3.
release it as quick as. Yes. Next.
Item 3.
What about 1, 2? Oh, that's it. Pronouncement.
Term 3, in the meantime, they have been already acquitted. They file a memo for conflicts.
What happened?
In the meantime, the two persons has already been acquitted. The present petitioners. That's why I file a memo for.
Withdraw. Okay.
Item 4.
Yes.
Wait, please, your lordship.
Yes.
Lord, in the instant case, the petitioner is challenging the order of cognizance at Annexure 2, order dated 25/2/2020, wherein the learned court below was pleased to take cognizance.
Not a complaint.
My lord,
It's a complaint case.
it's a complaint case. The complaint case has been initiated by the drug inspector in consonant with section 32 of the Drugs and Cosmetics Act.
Yes.
The
Offenses are 18C and 18A.
my lord,
of
18C,
Cosmetic Act.
my lord,
And
the allegation,
27B and 28 of Cosmetic.
my lord, the allegation is with respect to manufacturing of medicines for the purpose of exhibition and selling. That is the allegation. My humble submission is that, my lord, I am a veterinary doctor. I am a veterinary doctor. And my lord, the medicines were not for sale. It was for personal use. And my lord, those medicines that has been alleged that I have been selling those medicines and I have been manufacturing those medicines, no seizure has been made with respect to that, with respect to the production of bills or any sale books or anything with respect to that. Nothing has been made.
All these things are your defense.
Yes, my
You
lord.
read the complaint. If prima facie case is made out or not, you tell me.
No, my lord. It is only possession simpliciter, and mere possession simpliciter is not at all a offense under this section. That is what
Show
my
me from the complaint.
lord. Rosh, may kindly have a glance at Annexure 1,
First paragraph.
my lord.
First paragraph.
My lord.
That the complaint dated 23/1/2018 was received from the villagers
My lord.
of Sundar so-and-so village
Well,
regarding the stocking, selling of allopathic drugs
Drugs.
by one Surendra Chandra Ponda
My lord.
in the village so-and-so. The same complaint was also forwarded by the additional district magistrate Ganjam Chaturpur by so-and-so, so-and-so, so-and-so. This is the allegation.
My lord. But with respect to this allegation, not a single statement has
That
been
will
recorded
be-
by anybody.
That will be examined at the appropriate stage. In cognizance stage, the court has to see the complaint. If any case is made out, rightly, wrongly, whatever, right and wrong will be examined in the appropriate stage,
Yes, my
not
lord.
in the cognizance.
My lord. But my lord, what my humble submission is that, my lord, with respect to a judgment that I have been relying upon, it has been clearly stated.
That must be discharged.
No, my lord. The complaint entire proceeding was quashed.
That's right.
He was
My lord, and he, yes, my lord.
possessing for that reason, my lord. Here, not for the purpose of business, he kept the.
No, my lord.
That's the allegation.
My
There was.
villagers complaint here, my lord.
Yes.
That is not there in the villagers.
No, my lord. Here, another doctor has complained against him.
The villagers have given complaint to the district magistrate.
Without any
he
license
forward-
authority.
Yes, my lord. But the issue is that, my lord, there has been no seizure of any sale books or any receipt or nothing with respect to selling of those medicines, my lord. It was simply the possession simpliciter that has been made against me, my lord. And with respect to possession simpliciter, the honorable courts have again and again reiterated that mere possession simpliciter would not attract an offense under this section.
That is different angle, my lord.
No, my lord. Because in the judgment that I have provided, your lordship may kindly have a glance.
Here, my lord, last 5 years he is doing business.
No, my lord. I might be
5
doing.
years,
I might.
case, my lord.
I might be doing for a long period of time. But
And
if we go by the wordings of this section, my lord,
9.
page 9, my lord. My lord.
Read. Para, second para.
That
you
during,
research of the
that during the search of the premise, it was found that Sri Suresh Chandra Panda stocked, exhibited for sale, huge quantities of allopathic medicines of different varieties for sale without valid drug licenses issued in his favor. On demand, he failed to produce any drug licenses issued in his favor in respect of the drugs found from his possession premises and also supporting purchase bills or documents and sale cash or credit memo books, etc. for the verification of the rate team.
next.
The total 61 different items of medicines were found in the premises from the possession of Sri Suresh Chandra Panda, and the same was seized by Form 16.
Then you want me to pass the cognizance in the
No, my lord. All I want from your lordship is to kindly appreciate that what medicines I had in my stock, it
You
was
are a
simply,
veterinary doctor.
my lord.
What was the use of this allopathic medicine?
If you lord,
51 varieties.
my lord,
Why have you kept it?
my lord, my lord, it was.
Why have you kept it? Answer me.
Well, I have instruction that it was for his personal use, my lord.
61.
3 cardboard.
61 varieties of allopathic medicine found from the possession, huge quantity from a veterinary doctor. That's the allegation by the villagers. And the complaint was given to the magistrate. He forwards, a complaint is filed.
My lord.
Thereafter, you want that the cognizance order has to be quashed. How can it be possible?
No, my lord, but,
Will you withdraw or I'll write?
but your lordship may kindly have a glance at the judgment that I have given. Just a simple glance, my lord.
Well tried. Well tried, but you don't have a good case. We'll try.
Your Lordship, may kindly afford me one more opportunity.
I'll see that.
No,
Okay. Come on. Yes, tell me.
Your Lordship, may kindly have a glance
Tell me.
at the third page,
Which paragraph?
para 9.
9. Okay. Yes.
Now, what it has been said is that we therefore hold that a person can be liable for prosecution or conviction under section 27A 1 and 2 read with section 18C of the Act. It must be proved that by the prosecution affirmatively that he was manufacturing the
Underline
drugs
the word
for sale.
prove. Underline the word prove.
My lord.
When it will be proved?
My lord, but in this,
Cognizant stage it will be proved or some other stage? You are at the cognizant stage. It needs to be proved. You will be acquitted if they can't prove it.
my lord, in this case,
Allow them to prove.
the case was squashed, my lord, in this case because
That's
he
why
was
allow-
also.
Allow them to prove. Okay, allegations are very clear. Thank you. We will-
Lordship, may kindly grant me accord another opportunity, my lord.
No, I'll give best opportunity to argue all these things at the time appropriate stage. You withdraw and argue. You have different stages.
My lord.
This is a cognizant stage. Don't exhaust your remedy. The other remedies are available under CRPC. In different stage, you get opportunity. This is the first stage. So better that you reserve your right so that you can argue at appropriate stage. The land counsel for the petitioner seeks to withdraw this petition, reserving his right to argue all these points available to him at the appropriate stage. With this liberty, the petition is dismissed.
Grateful.
With your lordship,
You may persuade the court at the right stage.
But he has not been granted bail
I
in
know.
this case.
That's the reason you are here. That's
with
the
your,
reason.
with your
Next.
lordship's
Yes.
kind approval, with your lordship's kind approval.
Petitioner's vehicle was carrying molasses matters.
You get bail. What is this? You can get bail.
No, but as per the recent amendment, it has become non-billable in the
That-
drugs and cosmetic.
Now, but you get the bail now. Yes.
Grateful.
May I please? My lord,
That may kindly be observed in the, my lord, if.
I'll observe that you will get bail. Huh? Anyway.
Grateful.
Yes.
May I please, your lords? My lord, petitioner's vehicle was carrying a consignment of molasses, my lords. On 3/2/2023, the vehicle was seized by the excise department on the allegation that he doesn't have any documents. And the facts of the case, my lords, is that in the year 1999, in the Bihar Odisha Excise Act, the molasses was inserted as an intoxicant. And it was challenged at the threshold. It was challenged in various writ petitions, and this honorable court had granted stay. Thereafter, my lords, in the year 2019, a judgment was rendered by this honorable court, wherein this honorable court held that molasses, except for the purpose of distillery, the state has no control over it. They cannot levy any tax or cannot have any.
That is for the tax purpose.
Yes, tax
Yes.
purpose. And with regard to the part of license, there is no finding or any observation to that, but it is silent. Still then, when the vehicle was seized, the driver showed all the documents of the honorable court and everything, and the driver was arrested, and subsequently he was released by this honorable court. And the owner of the molasses material is a different person. He also filed a CRLMC under 482, and wherein this honorable court has been pleased to stay the further proceeding of the 2ACC. But when the matter was stayed by this honorable court, thereafter they initiated a confiscation case. And though by
Confiscation of the vehicle.
Yes. Because molasses by then was released, my lords. By virtue of the order of this honorable court, the molasses was released in favor of the owner of the molasses.
The same person, the owner.
No, owner of the vehicle, owner of vehicle is Varsa Agarwal, and owner of the molasses is Sumit Kumar Agarwal. That
Vehicle
is
was used by, it was taken on a higher basis or what?
yes, my lords.
Higher basis.
Yes.
Okay.
And the vehicle had all the documents pertaining. I have annexed
Right.
all the documents, my lords. And I filed an application that this case is not maintainable in view of the order of this honorable court passed in number of writ petitions. It was not considered, and thereafter they went on issuing notice. And when I got an order from this honorable court that I may approach the learned JMFC for taking, for release of the vehicle. When I file application, the excise department file a memo that confiscation has already been initiated since
So 457 is not.
not maintainable. It is a bar under section 72 of the Excise Act. So I move again. I move
72 of.
again. I moved before this honorable court because the same order, if I challenge before the learned sessions, it will be confirmed because again that embargo will be there, section 72. So I filed this application, and my contention is that when a notice was issued, it was not under it is not for confiscation of the vehicle. A notice was issued to produce the documents, and that notice which they had issued on 23/2, they have construed it as the confiscation notice and have given a misrepresented before the learned JMFC, and for which the
Let us see the order.
my lords. And that order is not under challenge before my lords, my lords. That order which the learned JMFC has passed, I have not challenged that, but it has been annexed. I am thereafter I also filed an application to release the vehicle after the order was passed by the learned JMFC.
What you are impugning the order dated 3/2/2023.
My lords,
Where is that order? 3/2/2023.
that is the PR, my lords.
No, which order you are challenging? Then confiscation proceeding. Where is that order?
My
By
lords,
which confiscation proceeding was initiated? Your prayer is not clear.
GMC rejected by as per Annex 6, page 54. 23rd.
You are challenging
Not
Annex.
challenge that order.
no,
What
no,
are
no.
you challenging? Just see the prayer.
I am challenging the initiation of the confiscation, my lords.
Where is that order of initiation?
My lords, that is the notice, my lords.
What is that notice? And it culminated into an order now.
My lords, that is
Confiscation order. Where is that confiscation order?
no confiscation order has not been passed because that has been stayed by this honorable court. The confiscation proceeding has been stayed in this instant criminal miscase.
It was earlier.
Yes, it was earlier listed before this honorable court, and this honorable court has been pleased to stay the confiscation proceeding. So the confiscation proceeding has not been culminated as on date. It is pending, my lords.
Acha, acha.
And before the order of stay was passed, I had filed an application for release of the vehicle.
Hmm.
And your lordship may
That
kindly
is
have a,
rejected.
my lords.
That is rejected now.
No, no, no. That is pending. That is pending consideration. No, no. JMFC, not before the JMFC, before the superintendent of excise.
Not challenge.
Acha, that is annexure 9, my lords. Dated 1/5/2023.
Yes.
1/5, wherein I have narrated all the facts and circumstances of the case and the order passed by this honorable court in 2019, and I have filed all the documents, and I have paid that since molasses has already been released, there is no justification in retaining my vehicle. So my vehicle may be released. Since the last 1 year, it is lying with the excise
So what do you
department.
say?
Which order is challenging, that is confusing.
No, he is
No, I am
challenging the entire
Confiscation
proceeding,
Proceeding cannot be questioned. my
which
lord.
has been stayed.
Confiscation proceeding cannot be stayed, my lord. And now, my lord, this is the final stage, my
But
lord.
it is already stayed.
At the
by
final
this
stage,
court.
my lord, they come to this honorable court, my lord, and
But if the coordinate bench of this court
My lord.
by order dated 20th, no, yes,
20th July.
July 2023 has stayed there.
My lord. But at the, my lord, I have sought for a one-page note from the Superintendent of Excise, my lord.
Huh?
It has mentioned that authorized officer and the confiscation proceeding is in the final stage.
What final stage? The court has stayed. This court has stayed.
That has been stayed, my lord. But in fact, my lord, he has also filed application before the court below, and that has been rejected. Here, my lord, the entire confiscation proceeding will pass.
See what happens is the confiscation proceeding, the entire proceeding is challenging.
My lord.
This court has stayed the confiscation proceeding. Meanwhile, since it is stayed, he moves an application that it is stayed, the confiscation proceeding is stayed. Please release the vehicle. The concerned authority is superintendent.
Superintendent of excise.
He says that I can't do it because it's sub judice. It is obviously sub judice. It can't be released.
Direction to move their application before the authorized officer.
Then I'll have to vacate the stay.
My lord. Lord, vacate the stay, my lord. And directly the petitioner to move their application, my lord.
Then I have to quash the confiscation. Then only it will be done.
Confiscation, my lord, will be passed, my lord. Then there is no question of, my lord, release of the vehicle, my lord.
No, if the entire confiscation, just see what is the case is,
My lord.
the molasses has been released.
My lord.
The molasses, in fact, used for industrial purpose will not come under. The molasses are used for distillery purpose and industrial purpose also.
My lord.
There are judgment of the High Court and it is pending in Supreme Court regarding that aspect.
My lord.
Whether it will be treated as the molasses will be treated as partly used for the purpose of distillery or it is purpose for industrial. How where you have released the molasses? Where is that order of release of molasses?
My lords, that is in the connected matter, my lords. Connected matter
Where is that?
1067.
It is
In
there.
that I had filed an IA.
Yes. IA.
In that connected matter, my lord, I had filed an IA, and in that IA was disposed of, directing the learned JMFC to release the molasses, and subsequently has released.
But that there is no final order.
Final order with regard to
This is an interim order by this court on the basis of which it was released.
my lords.
Because
Matter pending
there
for
also
the
there also a confiscation proceeding was initiated.
no.
No.
Then
That there the 2A CC is pending, which has also been stayed by the Hon'Ble Court, which has also been stayed by the Hon'Ble Court. In connected matter 1067 of 23.
what do you say?
And my application is pending before the learned before the Superintendent of Excise, that is Annexure 9.
You are
For
transporting where to deliver this thing?
Transporting from Manguli Chowk to Kapuria,
For supplying in a
supply to a Gudaku factory. And in the
distillery or where?
not distillery matter, Gudaku factory, Gudaku manufacturing
Gudaku
unit. Gudaku is a local toothpaste.
Anything is there on record?
Yes, my lords, I have filed the PR form, my lords. PR in the
Just
PR.
Then what do you say?
My lord, the Orissa Excise Act, my lord, 2008, my lord, section 2, definition. Section 2, T, my
That
lord.
is added. That is what he is challenging. That the High Court says.
My lord. But
That is under consideration before
Your
Supreme Court.
lordship vacate the stay and he may move before the confiscation confirmed, my lord, for release of the vehicle, my lord. Since his application is pending there, my lord. That was what
What do you say?
My lords, and only just I am just want to point out one thing. Then
This needs to be decided.
my lords, that needs
Because
to
you were taking these molasses for the purpose of giving it to the distillery to be used for alcohol, or it was intended to give it to some industry. That is the
that is the subject matter in the 2ACC, my lord. In the 2ACC is pending. During pendency of the 2ACC, I challenged the said proceeding in this court by in CRLMC 1067.
The Land Council for Petitioners submits first item submits that he had by Annexure 9, na?
My lords,
By Annexure 9, he had moved an application before the Superintendent Central Superintendent Excise for release of his vehicle. No, he has moved an application dated
dated my lords 1/5/2023.
1/5/2023, before Superintendent so for release of his vehicle. Inter alia narrating the entire sequence of events unfolded during the pendency of the present proceeding. It appears the application has not been decided by the Superintendent of Excise, Cuttack, in view of the fact that the present matter is pending and there is a stay operating against there is a interim order of staying the confiscation property. The without the superintendent of Central Excise is directed to consider the application of the petitioner dated 1/5/2023 on its merits without being influenced by the fact that the interim, without being influenced by the fact that this court by the order dated 20th July 2023 has passed the interim order. Has passed the interim. Least the matter. You go on.
One more thing, my lord, your lordship may kindly indicate that since molasses has been already been released,
That you will argue that you have written in the
and if your lordship will tell to consider as per law, I had been to the Superior Excise, he is telling that you deposit 9 lakhs for the
All
vehicle
people-
because the
you
RTO.
invite my intention is you invite an order, then you challenge that. You get a press cause of action. That's the idea. Go and do it.
Obligement. And the next
This
matter,
opening is given to you so that you invite an order. Thereafter, you can challenge that. You get a fresh cause of action.
obliged, deeply obliged.
You got stuck in the because of the interim order.
Time frame may be given.
The same may be done as expeditiously as possible.
Free copy. Free copy of the order.
Free copy.
In the connected matter, my lord, 1067, that
I am asking. The connected matter will be simply adjourned.
adjourn, interim order to continue.
MP not.
Obliged, my lord.
Yes. March. No, not this. Both the matters. March. Yes. Yes.
Item 6, my lord, I am filing that I am, my lord, amending the cost title to make the and consolidated cost title also.
Yes. Actually, you are making that
Yes,
victim.
my victim as a party, man.
Nillan Council for the petitioner moves an application for seeking amendment in the cost title, including the victim of the victim. The
Yes,
expression
madam.
is victim.
Yes, my lord, victim.
Victim.
Yes, madam.
It's opposite party number 3. The amendment application is allowed, and opposite party number 3 is notice has not yet been
No, madam.
issue notice to the newly amended opposite party number 3. Yes.
2 also there.
Two notice has already been
No.
issued, na?
No, my lord.
Issue notice to the opposite party number 2 and newly added opposite party number 3.
My lord, interim order, my lord.
Now, what was the case?
Case was with regard to that section 92, where proceeding was initiated, cognizance was taken against us, my lord, being the occupier and the manager. So, my lord, on the ground that violation of section 7A 2C and section 22, in my lord,
Have you given compensation?
compensation, they have to go for the compensation. Case is a different thing, my lord. It has to be, then, my lord, the insurance company has to be made a party, then entire thing has to be.
No, factory and the factory.
No, my lord, no compensation, because they had to initiate the compensation proceeding, my lord. Till now, they have not initiated any compensation proceeding. Compensation proceeding has to be initiated by the employment. Until unless it
What do
is.
you say?
Start date may given. Otherwise, you must have granted it to comment. Start date may.
Because in other two cases, my lord, stay is already
The
there.
whole idea is to see that, these are the people, the owners, and staying in Bombay.
Yes, my lord.
He is not a direct control of the factory, operation of the factory. The lever, both the lever, there are two levers. There are two levers, their hands are chopped off because of some negligence, technical negligence and all. Why to is at the what you have to see is the labor have to be compensated first of all. They have not initiated compensation proceeding. Prosecuting this gentleman, whoever it is, will lead nowhere. Ultimately, see what I'll do is I'll stay, but the stay will not
Extended.
come in the way for the compensation.
Yes, my lord, that is a different proceeding altogether, my lord. And my lord, one thing, my
Issue
lord.
notice to so and so, the interim order, interim order. The proceeding, the further proceeding in 2CC, you take it from interim order, huh? Interim application, initiated against the petitioner, pending before the learned SCGM Titlagarh is stayed till further proceeding. However, it is made clear that the stay will not come in the way if the victims have applied for compensation or any proceeding initiated against the petitioner or the factory regarding the compensation, entitlement of compensation of the victims, namely opposite party number 3.
My lord, there is another case also, Prashant Kumar Naik,
There are two
two cases.
Both the cases the same order.
My lord.
Both the cases separate order. You take different numbers and all. So that at least they'll get the money.
Yes,
That's
my
very
lord,
important.
because that is a totally
proceeding
different.
will-
And there, my lord, they have to establish whether there is a negligence on our
That
part.
is a
or-
different story.
Yes, my lord.
But you can't
So-
pay up, you can't use this stay.
No, my
for
lord,
their-
we cannot do that. We cannot do that.
You file in the registry, get it numbered?
Yes, my lord.
Yes. Notice, give it first week of March. 6th.
March रे नौ रहते, April रे आसो.
That is the reason I don't give stay.
चल ठीक है, March रे आसो, March.
Once you get the stay, then you have got.
No, my lord, March रे.
That is the only reason I'm not giving in 482.
My lord,
If you satisfied, help us.
my lord, March.
And thereafter you will send your junior.
No, my lord, I never said that.
I'm not well, I'm busy, all these things will start.
No, my lord.
The difficulty of a lawyer, your lordship knows better than others.
But the difficult of court also you should know.
While your lordship in this side.
Item 7.
May I please, your lordship? Your lordship heard this matter in,
Yeah.
and due to the.
Not agreed with you.
No,
Hmm.
agree with me and going to quash the entire proceeding because I have vividly submitted before this honorable court that case has been initiated in the year
For that, my lord, scan copy of the.
Your lordship may can see.
My lord,
There is no-
discount, my lord.
Sorry, what?
A scan copy, photocopy of the order sheets, my lord.
Okay.
Your lordship wanted to whether there is a fault lies with the present
Yes, yes.
petitioner or not.
Yes.
There is no fault lies. I have verified that flag B towards last month.
Flag?
B, most probably that has been noted in
Noting there.
noting is there. Owner of the query is somebody else. That is Tinnu alias Lakshminarayana Jain. The case has been initiated in the year.
Let me rephrase what is the case.
The case, my lord, is that the owner of that quarry, stone quarry, he has taken that in lease. It has been alleged that some persons, the owner of that quarry, using some explosive substance for extracting that is from the stone from that quarry.
Hmm.
The police person getting that such information, they have proceeded and initiated the proceeding. That much allegation. That is the sum and substance
You
of
are
the.
the owner of the quarry.
No. Owner of the quarry is Tinnu alias Lakshminarayana Jain.
You are?
I am other employee. Employee and one of the person is his tractor.
I know. You are Ajay Goyal,
My lord.
Jama Ali,
My lord.
and Abdul Salim.
Abdul Salim.
Abdul Salim and Jama Ali are the employee.
Employee and one of the persons tractor has been used for.
No, who is Ajay Goyal?
Ajay Goyal, one of the employee of Lakshminarayana Jain. Lakshminarayana Jain is the owner of that quarry, stone quarry. My lord, page 23.
You were taken the quarry
That Lakshminarayana
on
Jain.
lease basis.
Lease basis, my lord.
Okay. And you, yes. Why I asked for what is the order I have?
Because, my lord, the case is pending. This is the case, my lord, where the case has been initiated in the year 2011. After lapse of 4 years, charge sheet has submitted. Till today, there is nothing. For that reason, your lordship wanted to quash the proceeding, whether the fault lies with the present accused persons or not. There is nothing on the record that the present petitioner, they are appearing on the each and every day. That is there. They have also executed the PR bond, everything.
Yes, when the proceeding was started?
23/8/2011.
What is, yes, Mr. Raghuda, have you seen the earlier order of the coordinate bench? You see 18/9/2000, that's the reason I've called.
Mail.
The coordinate bench says, Mr. A. Das, land counsel for the petitioner, submits that in response to the summons, the petitioner has appeared on 2015, before the court below, and thereafter steps have been taken on behalf of all the dates, but till date no witnesses has been examined, and the trial is stands still, and which they are seriously prejudiced, and they pray for quashing of the proceeding on the ground of delay.
Delay.
That is the reason proceedings were summoned.
But in the meantime, what happens, my lord?
Yes.
22, the case has been committed to the Court of Sessions, and the ST case has already been registered, my lord. 2022, my lord. ST case, my lord.
Now, from 2011 to 22, what have you done?
My lord, that is my lord report call.
See, this is not, I can't just read it also.
My lord.
With respect to the humble submission, I am forwarding here with the copy, but these proceedings, handwritten proceedings.
And the meantime, in 2022 case, already ST case is instituted, my lord. 34/22, my lord. And the trial may be expedited. An opportunity, even since ST case has already been registered, my lord. That is pending.
How many witnesses there?
All total, my lord.
11.
11 witnesses.
And that,
Vice President wale.
and that happened, my lord. Your lordship may ticket.
Trial.
So, but trial.
No, just have you gone through these proceedings?
My lord.
My lord, only
See, these proceedings, the proceeding has been initiated in 2011.
11, my lord.
And what are these proceedings? You have to read every proceeding. It's not visible at all.
Based on
Not visible.
Lordship may kindly pass it
And the
over.
scanning is also done like that. Huh?
Pass it over, I will verify.
I'll pass it over. Let it
Yes,
see.
I will verify.
You just see
Yes, yes.
what can be done. That's the only reason it was
Yes, yes.
thought for. Okay.
Another thing, my lord.
Another thing after password.
1 second, my lord. There is no allegation against us.
That we'll see. That was not the
Based on
reason for calling for the proceeding. Proceeding is 2011. It was initiated.
My lord. On
We have passed a decade, more than decade.
My lord.
Nothing has happened. So therefore, it is has to be
My
passed.
lord.
If it is not attributable to you.
My lord.
That is the idea of
my
the
your lordship is
statement.
correct. On 29/1/2024, your lordship objected.
But that is not brought to the honorable court, my lord. While the honorable court passed the order, my lord, earlier, my lord, coordinate bench, my lord. The ST case was instituted, my lord. My lord,
That is in 2022.
my lord, that is
Thereafter, what you have done?
my lord, that is, my lord,
That you just see.
Challenge question cognizance.
cognizance challenge person. They have
No,
challenged the cognizance order.
Now the case has already been committed and the ST case has been registered.
Registered.
So now the cognizance is itself, how can
And
it
that
be
is comment-
interpreted?
Let us see.
But that
Don't
is-
go by the prayer. The coordinate bench says that
I'll
it is
verify.
delayed. So therefore, we can't ignore the order of coordinate bench.
My lord, the court passed an order, my lord, only because the coordinate was not aware about the fact that.
Let us
the
see.
ST case is registered, my
Let
lord.
us see what
But that is
Pass
with
it
the
over.
knowledge of the my lord, council for petition, my lord.
we will see after.
Yes, sir.
That ST case has already registered, my lord. He
Yes,
has not
next.
mentioned that.
Next.
Item 8.
It will taken up, my lord. After
Yes, possible.
My lord.
2:00.
Madam, the petitioner challenging the order of cognizance, my lord. I annexer 3, running page 27, my lord. Order dated 31/3/2023, my lord. 31/3/2023, my lord. And my lord, on last page, though, charge sheet was submitted and
What is the offense?
25 arms act, my lord.
Yes.
And, running by 17, charge sheet was submitted. I submitted preliminary charge sheet 25(1)(b) of Arms Act against the accused Sheikh Babu, the present petitioner, with prayer to keep investigation open 173(8) for sending the seizure list for executive officer Rasul
What
Garg.
is your case,
That's
you
it.
tell me?
My lord,
Why it should be quashed?
my lord,
Cognizance
there is a sanction order not received by the IO and charge sheet was submitted. And initially, prior to that, the court below, without receiving a sanction order, cognizance was taken. And it is well settled by the our some decision also, and that is the provision. The sanction was it is, and that about two judges in
25, huh?
my lord.
Which provision you are reading?
25 1B also. 25 1B.
Yes. Read it.
Read it, my lord. Hello, one whoever ICOR has in his possession or carrying any firearms or ammunition in contravention of section 3. My lord. Then section 3, my lord. And my lord, sanction order 39 also before that.
Which provision you are? Sometimes 33, sometimes 39.
25 1B, I'm reading.
Yes,
Thereafter, sanction order is
your
required.
case is the cognizance is taken. 25 Arms Act has been imputed against you. Cognizance is taken without there being sanction.
No, but
That's what your case is.
not only cognizance taken. In the meantime, SARS already
No,
framed.
he is challenging the cognizance order.
Yes.
SARS framed, my lord. And he has-
Maybe charge frame if the cognizance order with sanction is pre-requisite. If sanction you have not taken, everything falls. That's what his case is. Show me the provision.
36, 39. No prosecution shall be instituted.
Provision.
Section 39.
39.
9.
Yes.
Previous sanction of the district magistrate necessary.
Prosecution shall be instituted against any person in respect of any offence under section 3 without the previous sanction of the district magistrate.
Yes, madam.
That's what you are saying.
Yes.
Now,
But-
yes.
My lord. Now, the court below has committed seriously illegally. Instead of taken cognizance 25 1BA cannot be taken as sanction is required. He has reflected in the cognizance order. Then he cognizance taken on 25 1A Arms Act
Then?
without any prima facie material, because IU has submitted charge sheet. only-
Charge framed under which provision?
SARS framed, my lord. 25 1A, my lord.
25.
1A. Arms Act, my lord. And also the petitioner, my lord, claims for trial, my lord. They are in charge, my lord. He claims.
No, that is obviously charge frame. That is a formal order.
They are not-
You show me 25
1A.
1A. Read 25 1.
25 1A. Where there is sale, transfer, convert, repair, test, or proof, or expose, or offer for sale, or transport, or has in his possession for sale, transfer, convert, and repair, test any arms and ammunition in contravention of section 5.
But for that sanction is not required.
Madam?
For that sanction is not required.
Okay. But in both the judgments, only 25 Arms Act sanction is required.
So,
In my lord,
provision irrespective of 5 or 3.
whatever.
25 means sanction.
Sanction.
Show me. Show me the
But,
judgment.
that judgment I have given.
Yes.
No.
Which page?
My lord, second page, my lord. 25,
Para?
my lord,
Which judgment you are reading?
my lord,
You have not, I think you have not prepared.
me, I have given copy.
Are you sure that you have prepared?
Yes, my lord. Take
Which
take me
judgment?
next. Take me next week also.
Which judgment? I
Wait,
understood. I
Just
wasted 10-15
Bali-
minutes. I'll finish it up.
my lord,
Which judgment you
2002,
are reading now?
2002, 22 OCR, my lord.
Yes. Which para?
My lord, on page of 8, level 2, second para, Arms Act,
Which paragraph, sir?
third paragraph
Yes.
of second page.
Sri Sahu. Sri Sahu, learned counsel appearing for the petitioner, referred the different provisions of Arms Act as well as the Indian Exclusive Act. Submitted that even accepting the material stated above, that's what you are reading?
Sir, take good.
You just tell me the paragraph. What is this?
For a very top page, I am reading. But there is an allegation against the petition. I am that court title. I am reading that statement. Second page.
Which paragraph? Head note you are reading, paragraph you are reading. What are you reading? You just, what is this? I just don't understand.
Para running page of that long page. Para 5.
Para 5.
My lord.
In the light of the argument advanced by Mr. Sahu.
No. Para 5 in the light of argument advanced by Mr. Sahu.
That's what I'm saying.
Yes.
Read it.
And I have not completed all the provisions, but what is the important
Adjunct-
relevant part?
Adjourn to April. April somewhere. Next.
Item 9.
Then next week.
No, April. I can't waste time like this. I would have finished this matter by now. You're taking me this, there.
Only top of
Yeah,
the, I have top of the page. It was reflected allegation against the petitioner for the possession of Arms Act in contravention to section 3.
Anyway,
Placitum I am reading.
leisurely, no problem.
I am reading that Placitum.
Leisurely,
Only.
no problem.
After learnment.
Leisurely you read and come. There are many judgments, you come. I'm giving enough time. to you.
Because that in the meantime, though, accuser is in custody also.
This court is not.
No. But when there is a court below without taking prima facie, without.
Anyway, let us see.
Instead of one with, he has.
Give it little early.
Next week.
February last week. We'll see how we can adjust. See, every minute is important. I want to dispose it up. And if the assistance comes from this level, then I can't waste time for other people, you know. You got an opportunity to come with full preparation. Issue is not such a big issue, constitutional issue. It's a small issue. Anyway, he'll give the date. Yes, next.
My lord, my lord, I am filed this application for the in-laws, questioning of the proceeding.
Yes.
Here, my lord, the offence alleged, my lord, 498 along with the other offences filed by the informant.
All
Again.
who all are they?
My lord, all are my lord in-laws. Father-in-law, brother-in-law, married sister-in-law. They are staying separately, my lord, from the husband, my lord. Husband is not there in this petition, my lord. Husband, my lord, whatever torture, my lord, meted by the husband.
I know. What is the allegation?
All the, your lordship kindly see the FIR annexure 1.
Where the husband stays?
My lord, she is all along staying in her parent house, my lord. It is the allegation. After marriage, he came to our house and we torture. He went to her parent house. There he born a male child born. Again, allegation is that we are not going to see the child. Thereafter, she went to her.
Where the husband of the victim, he stays with you or?
We are staying in my lord.
Your house.
Yes, my lord. After disturbance, my lord, this family member, my lord, separated, my lord. He is the elder son, my lord. She always picked up quarrel with the her husband, my lord, for separate mess. Being a
drawn up proceeding under 13.
no, my lord. Husband, my lord, we have not, my lord, not know whether he has filed or not, my lord. We are not concerned, my lord. Here, my lord, the allegation against this petitioners, my lord.
You are concerned. He is also staying with you only.
My lord, now, my lord, he is
I
not.
can understand if she stays somewhere else, you don't know and all.
My lord, this is my case, my lord. Now he is not staying with the my lord, us, my lord.
I'll simply issue notice. Let us see if something can work out. Issue notice. to the opposite party number 2.
By registered post, my lord.
Week's notice.
By registered post, my lord.
By registered post.
And the application for interim application will lie.
Notice on the interim application as well. Yes. Only to see that find out some way out and send to mediation and finish it up.
Yes, my lord.
But matrimonial dispute.
Yes, my lord.
Spur of a moment things happen, you know.
Because it
in a
is
family.
matrimonial discussion and
I
strong
could-
is also there.
I
my
could see the number of people in your family. It's
and
a-
also the honorable affairs court also
he
time and
he
again, my lord.
might not be in a position to adjust in your
Yes,
family.
my
That's a big family.
That is.
So there must be some misunderstanding.
Yes,
Let us see. Let her come.
My lord.
We'll see.
I can tell.
Yes. Yes.
The petitioner has challenged the order of the answer 2, my lord.
Yes.
5 petitions were filed by the petitioner, my lord. Out of 5, 1 was allowed, and out of 5, 4 applications were rejected. And no reason is assigned, my lord. Your Lordship may kindly-
Sorry, 31/7/2023. Yeah. Annexure
Yes,
1.
my lord. Yes.
What are these orders?
Order is at answer 2. Your Lordship may kindly see page 15. No
15.
reason is assigned.
No, 15.
Yes. Last portion of the order.
Annexure 2.
So far as the other petitions are concerned, I am of the view that the petitions are no way relevant to the facts in issue. It seems that filing such petitions, the Law and Defense Council is beating around the.
What are the applications? 5 applications you
Yes,
moved.
5 applications were filed, my lord. One is the petition to permit to examine the under trial prisoner himself. That was allowed.
315.
Yes,
Yes.
that was allowed. Second petition is, my lord, to cause production of general diary from the police station. Third is, my lord, to summon the diary to prove the case, diary from the police station. And fourth is, my lord, to direct the authorities of meteorological department to produce some documents. And the 5 is to summon the editor of a news channel to prove some documents, my lord. The case is completely.
313 statement is recorded.
That is the record.
And thereafter you want that the prosecution should do every defense evidence for you. You are asking everything under the sky, bring for me so that I will be acquitted.
They are relevant for the case, my lord. Because, my lord, on that day, my lord, cyclonic.
Where is 313? Show me.
My lord,
313 statement.
313 was allowed. That was allowed.
No, 313 accused statement. You, unless you see that accused statement, how will you see whether it is relevant or not? These are, you want to lead all these things in defense.
My lord.
So that will germinate from your 300, whether the witnesses are put to these questions or not. Where is 313 statement?
That was done later on, after filing of the case. That was allowed or done.
Let us see then the relevancy of these 4 applications or 5 applications could be decided on the basis of if the witnesses, the evidence is not put to you. Why should you waste your time?
My lord. Yes, my lord, your lordship may kindly allow some time. My lord.
Did you follow what is running in the mind of
My
the
lord,
court?
yes.
The land counsel for the petitioner seeks time to file the accused statement under section 313 CRPC to analyze the relevancy of the application, 5 application he had moved before the trial court for the leading his defense evidence. And this let the petitioner file the statement under section 313 CRPC, leaves the matter on 27/28/7.
Further proceeding may be.
No. Defense evidence, how can it stay like this?
Posted for argument.
No, maybe you move application. Then counsel for the petitioner submits that you would be moving application before the trial court seeking accommodation.
Of the 14 course of the day.
My lord, senior may be directed to file the modified cost item, my lord. No certificate given.
Sorry.
Do all these things unnecessary. If you see 313, I will tell you these relevancy of these applications may not be there also. Yes.
By item 11, I received the brief from the petitioner after no objection.
Sorry?
After no objection given by the earlier conducting counsel, I received it just now. I will file the Bhakaltama in course of the day.
Urgent. Yes.
Item 12.
My little prayer before Lordship, in for prayer. This honorable can be directed to the court below to complete the
I'll just,
time, with a stipulated time.
you want that it should be expedited.
Trial distribution. That much.
What do you say, Mr.
That is a
Lata?
complaint case arising out of 138 proceeding.
By the time I come, give a copy. If it's small matter, we'll do it. Small matter, we'll do it. Right.
One CC case number 102 of 2016. The company who was issuing the check in favor of the present petitioner, they were taking time.
Where is the proceeding?
Proceeding, my lord, before the Learned JMFC or Udit Nagar Raukala.
Now, show me whether who is delaying it.
That the complaint, because as per the statute 138 enact is to be completed.
That statute, forget it. All the statutes says so many.
Show me. Only by my.
Show me the proceeding. Why it is delayed?
Because due to the non-cooperation of the accused persons.
How? Let us see. You filed the complaint on? Filed on 20th December 2016.
2016, my lord. They have taken out things and issue check.
Cognizance is taken in 26th of December 2016.
Immediately. A person who lost everything, now he is aged about 67 years old. I have annexed the complaint petition.
I think you deserve cost in this case. Have you read your proceeding?
That proceeding, my lord.
Have you read it or simply you
No, my lord. I have got that certified copy.
Then how much cost will you pay for this petition?
Because it was, my lord.
And every date you have taken, being complainant.
Myself, man.
Yes. Shall I read it one after another?
My lord.
I'll just read it. This is the danger you have. This petition is by way of this petition. The petitioner is seeking expeditious disposal of the complaint ICC case number 102 of 2016. The petitioner is the complainant in the case. He submits that the delay is inuring to his disadvantage. He relies upon the proceeding before the court below. Perusal of the proceeding indicates that the delay is largely attributable to the complainant only. I'll read it out, one after another.
Just one.
One after another. So therefore, don't bargain risk of throwing papers without reading. Just see. 22nd 12/2016, the case record posted today and cognizance was taken. Thereafter, cognizance was taken on 26/12/2016. Then what happens? In 18, matter is listed on 18/1/2017. Advocate of the complaint file Hajira and requisites of accused file. Thereafter 8/2/2017, the accused appears and takes. Thereafter, what happens? And 15/2/2017, complainant is found absent. No step is taken. And 22/2/2017, complaint is found absent. No step is taken. And thereafter, what happens? 4/3/2017, complaint is absent. No step is taken. And 15/3/2017, advocate of complaint is filed Hajira, accused is absent and so on. So. Next is advocate for the complaint file Hajira and undertakes to file the undertakes if the file and the record is posted so and so. And thereafter, land counsellor both the parties are present and so on so. Next, advocate for both the parties are present, files Hajira. Land advocate for complainant is present with one witness, namely so and so. He has examined so and so. One witness you have examined.
That's the complaint.
Thereafter, just see thereafter. Advocate both and advocate for complainant files time petition. And next again date. Advocate for complainant files time petition. And present witnesses named so and so present. Land counsel for the accused present so and so. And both the parties present. One witness, same witness you are examining. Okay. He cross-examined and discharged. Okay. The land counsel for both the parties present. However, put it. And advocate for the complainant files deposition of PW2. First time in 2018 again. And so and so. Advocate for both the party present. Advocate for the accused files petition for so and so. Complainant is filed praying for time. Again, you file that complaint. And court adjourns the matter. Court adjourns the matter. No step is taken by the complainant. And advocate for complaint is present. And today bar is on strike. And bar is on strike. And accused is absent. No step is taken.
That is on that day, my lord, warrant.
And picketing takes place and so and so, so and so. And both the parties are present. No step is taken due to corona. How will I get in this?
Because, my lord, I have already filed my deposition.
Either court is the bar is strike, corona, or you have taken time.
No, but I have
largely you have taken time.
No, I have already filed the deposition of the PW2. That has not been cross-examined till today.
You just read it and you tell me what should I do.
Your lordship, I will be targeted because.
No, why should I target? I will impose cost.
Because, my lord,
for privilege
always, my lord, your lordship, prime is 67 years old now.
Maybe
and
if that is the case, then you should have prosecuted the complaint in diligently.
I have appeared. I have given my chief examination. I have been cross-examined. 138 enacted.
After reading this proceeding again, you are telling all these things to me. You read yourself.
That is
what have you done?
The advocate for the complaint is present and files Hajira. 2 to 3 days. I have gone through that, my lord.
Just read from beginning. Do you want me to count now again?
No, count.
Then? What are you doing?
Gotte dita date mu appear kani. 15 22.
Complaining or due to the strike of the lawyer, the matter got adjourned 10 to 10. Therefore, no interference is called for in this petition. It is dismissed.
ଆଜ୍ଞା ସେ କେସ୍ଟା ବି ନିଆଯାଉ ସେ କେସ୍ଟା ବି ମୁଁ ଦେଖିଥିଲି ସବୁ
ସବୁ ତାଙ୍କରି ଆମେ ଏଣ୍ଟାୟାର ଡେଟ୍ ଗୁଡା ସବୁ ଲେଖିଛି
ଆପଣ ରଖନ୍ତୁ ଦୁଇଟା ବେଳେ ତ
ସବୁ ଗୁଡାକ ସେ ଟାଇମ ନେଇଛନ୍ତି ଆଉ କଷ୍ଟ ବାହାରକୁ ଦବା ଦରକାର ଠିକ
ମୁଁ ଟାଇମ ନେଇଛି ହଁ ମୁଁ ଦେଖିଦେବେ ଆପଣ ଯଦି ଥିବ ମତେ କଷ୍ଟ କରିବ ନହେଲେ ଷ୍ଟେଟ୍ ଉପରେ କଷ୍ଟ କରିବ
ଏକ୍ସାକ୍ଟଲି ମାଇ ଲର୍ଡ ଏକ୍ସାକ୍ଟଲି
but it will go to the same fund.
ୟେସ୍
କୋର୍ଟ ଅଫ କାହିଁକି ମୁଁ କହୁଛି
ମୁଁ ଆଜ୍ଞା କଷ୍ଟ ଦବାକୁ
At 2 o'clock, in any case, we are doing.
ବଢିଆ
I am submitting 1 second.
ହବ ଡେଭଲପ ହବ
This is their duty, not the duty of mine.
Okay, let us
Oh,
see.
Babu.
2 o'clock we'll see.
ହଁ ତାଙ୍କୁ 2 କୋଟି ଟଙ୍କା କଷ୍ଟ କରିଦେଲେ ଆଉ କରିବେନି
This movement is not good for you.
I think while your lordship is there, every time, every second is good for me.
No, 2 o'clock would be more auspicious for you.
କିଛି ହବ ଆଜି ଡେଭଲପ ହବ ବାହାରେ ଡେଭଲପ
State council ଦେବେ last କୁ ମୁନା ଆସେ ତମ
Yes. The one I did with, yes.
May I please, your lordships? The petitioners have sought for quashing of the entire criminal proceedings
Yes,
on the ground of a compromise, my lords,
yes.
arising out of section 498A
Where is
IPC,
the, why?
and my lord, it has come up for fresh
Okay.
admission.
Acha, okay. Issue notice to the land council or the petitioners submits that no, this is a matter arising out of a matrimonial and discord. The council for the petitioner submits that the parties have settled their dispute amicably, separated or
Already divorced by mutual consent. my lord. I have annexed the
on the
copy of the
basis of
judgment
their,
and decree, my lords.
settlement. The parties have also obtained the divorce by mutual consent.
Yes, ma'am.
Mutual consent. Issue notice to the opposite party number 2, returnable next week. You file the affidavit, will she come?
My lord, if notice goes, it will be better because they have
You paid,
they have appointed a separate.
Have you paid alimony and all?
Yes, yes, my lord. Everything we have settled only because my instruction is she wants to appoint some separate lawyer from Bhubaneswar. So she will appear through her
And
own
if you
lawyer.
have a good relationship, tell her to appear through VC. Will
I'll request the council.
Yes. If she can't come, let her appear on VC.
Through VC, my
Yes.
lords.
7th.
7th of March, my lords.
No, not March.
February, my lords.
February.
Yes, my lords.
You have settled, why to waste time?
My lords.
Yes.
I have moved an application for interim orders, but
What interim?
it'll be-
Yes.
oh, blessed.
May I please, my lord? And, the petition is the informant. And OP number 2 to 5, they are the accused, my lord.
No,
Before the court below.
informant is the petitioner.
Petition, my lord,
And what do you want?
He wants to drop the proceeding, my lord, on the ground that matter is compromise between the parties, my lord.
What is the offense?
My lord, the offense is, my lord, that page, my lord,
323.
Yes, 27,
No. The petitioner is the informant.
yes, my lord.
Petitioner being the informant has registered an FIR, a number so and so, FIR number so and so, under section so and so.
Yes, my lord.
The opposite party number 2 and 3 are
Two,
the
my
accused in
lord,
the
2 to 5, my
2
lord.
to 5 are
Yes,
the accused in
Yes.
the
Court below, my
said
lord.
FIR.
Informant is.
By full stop. The by way of this petitioner being the informant in the case
Yes, sir.
seeks quashing of the proceeding on the ground that he has entered into a settlement with the
And received the amount of 7 lakhs from the accused, my lord.
whatever opposite
Yes,
party. Mr. Ragada accept the notice on behalf of state so and so, and yes, returnable within next week.
And 2 to 5, he's appearing for the accused, my lord.
Mr. So and so has filed Wakalatnama on behalf of
2 to
opposite
5.
party number 2 to 5 on advance notice. Advance notice. Where are they?
But the informant is there, the, my lord, the informant, he is there, my lord.
What was the allegation?
My lord,
Just Mr. Ragada.
assistant there my lord
but he has taken a, my lord, vehicle from the finance company, did not pay the amount. The vehicle was taken away with the finance company.
Who is taken?
The
Which
informant has taken a loan, my lord, have purchased a, my lord, vehicle from finance company, Muthoot Finance, my lord. Did not pay the amount.
These are the people of that
Yes,
company.
in a finance company, my lord. They
They
are the
went
accused.
for collecting money and
No, no, they are the official of the finance company, my lord.
now he has
And now he has already received the 7 lakhs from the accused person, my lord. The filing the affidavit, my lord. He also present in his court, my lord.
he has taken 7 lakhs.
Yes, my lord.
Very nice. The loan also, money he has paid
Loan
or
was
not?
closed and he also received the 7 lakhs from the finance company.
As
The
a
in-
compensation.
Yes, my lord.
This
And
is
also
the-
he is there, my lord.
This is the extortion.
Not my lord, finance company has given the, my lord, the vehicle was given the loan as the petitioner. The informant, my lord. Vehicle was purchased.
Informant had taken loan from the
No,
financial
no, he has
institution.
purchased a vehicle from the finance company.
Okay,
Yes, my lord.
he defaulted.
Defaulted.
So therefore, these people went for collection.
Vehicle.
There is something happened, FIR was lost.
Yes, my lord.
Now, instead of the informant paying the loan back, he has taken 7 lakhs.
Yes, my lord.
So extortion or what? This is not extortion.
Extortion, my lord. He has taken money from the finance company as a compensation, my lord.
Why compensation?
Because the vehicle was not refunded to him, my lord. The what vehicle he has taken from the finance company was not given to him, my lord. In lieu of that, he has given 7 lakhs.
You might not have paid back the installments.
Well, I am the finance company, my lord. The owner. I am the
You are the informant.
Yes. I have not paid the amount, my lord. That is why.
You have not paid the amount.
Yes, my lord.
For that, the vehicle was
Taken over the finance company. Yes, my lord.
And you lodged an FIR.
Yes, my lord.
Didn't pay the money
Because
and taking 7 lakhs from them.
So, but they also agreed to pay the
This is
amount.
not extortion.
Yes.
The FIRs are being registered for this.
Yes, my lord.
Call them next week. We'll see. I'll have to impose heavy cost for question.
No, my lord,
These FIRs are not meant to, arm twist the people and extort money like this.
no, my lord, what happened, my lord?
Why have you taken 7 lakh rupees?
Because I have, my lord, the vehicle was given on loan, my lord.
I know that. I understood it.
Yes.
And you also understood it.
Yes, my lord.
But why have you taken 7 lakhs from them?
But they have because they have sold the, my lord, vehicle to some other persons, my lord. That is why they have given the.
You don't pay the installment, they'll take it up. That is a different story.
That's true, my lord. Now the matter is settled between the parties, my lord.
If you register this kind of cases, anybody will be scared and they'll pay. What to do? If then the very fact that this you have settled by taking money goes to suggest that this is a false case posted against them. You have extorted 7 lakh rupees.
Not extortion, my lord.
And that is the reason these people are not coming. They have paid money and they suffer also being employed.
At the end of the day, my lord, the matter is settled between the parties, my lord. So further proceedings
you file a false case.
It's not a false.
Money,
no, it is not a false. No, it is not a false.
Do it.
No, it is not a false case, my lord. It's not a false case, my lord.
Call the IO also. Monday, Tuesday. Call IO. Let us see what is this case.
In this case, the police submitted.
The idea is we shouldn't encourage this kind of people.
That's true, my lord.
In the society.
Yes, my lord.
So, SC/ST Act is meant only to protect the real victims. And if it is misusing this for extortion.
So it is, my lord, in all the cases, not, my lord, the same, my lord. Some cases, my lord.
We have to examine whether this case it is there or not.
In that case, my lord, police submitted final report.
You use judicial process for the purpose of extortion. Then we have to stop something.
And also, my lord, the police submitted final report, my lord, against the accused persons, my lord. Thereafter, court take, trial court taking cognizance, my lord.
That is why IO.
No, IO submitted final report.
I know that. That's the reason this is a false case.
Yes, my lord. But the trial court has taken cognizance because the offense made out against the accused persons, my lord. That is why
it's a false case.
Lord. That is why police submitted final report, my lord. I annexed the final report.
Notice and tell the accused person the
informant is there, my lord.
You are informant, sir.
Yes, I am there.
I want accused person to be here.
He is appearing for the accused person.
You ask them to appear. 6th. Take it out.
Yes, my lord.
Take it out.
6th. I'll call the
I can understand if the accused come and say that I paid. Please quash it.
That's
the informant comes.
Because they have came earlier, my lord. That is why
it speaks a volume.
Not so volume, my lord. Petty offense, my lord. What is there? 3.
What petty? SCST.
It is also, my lord.
Why are you so eager to come to this court?
Because, my lord, since I have received the money from the company, But so
They might have said you take the money, get it quashed and come.
that might be in the abroad.
Because you have falsely implicated us.
FIR is there, but that is why. My lord.
Let them come and appear.
Yes, my lord.
IO.
Yes, my lord.
IIC through VC. Don't call to the court.
You also at least, my lord, because they are coming from my lord, Calcutta, so let me at least 2 weeks time, my lord, because my lord, they are not.
Okay. Let it be on 18th. 18th. 19th.
Yes, my lord.
Okay, 19th. Yes.
Item 15.
Let them appear through VC. They need not come unnecessarily. From Calcutta, why should they come?
Exactly.
Let them appear on VC. Yes.
But I have filed a miscase for I will take my adjournment before the court below.
You are the informant, sir.
The trial is going on.
Is it hurting you?
No, not hurting me, but I have to go to the
If
court.
the accused are asking for stay?
They are not paying for stay, my lord.
I don't know why you are so anxious.
Yes, my lord.
You are the informant.
Yes, my lord.
You are asking for stay for your own proceeding.
No, because
Accused
my,
are
because my
silent.
summons will be issued against me, I will go to the court for to give evidence.
You go whatever you have initiated against them.
That's my lord.
I can understand if they ask for stay, I can understand. You are the informant, you are asking.
Because I have paid for costing.
That goes to show.
No, that is not there, my lord. That is not there, my lord.
It's very unfortunate. This if something comes out, then I'll impose 7 lakhs you have taken from them, na?
Yes, my lord.
You have to pay double the amount. Be ready for that.
No, my lord.
If you misuse the law like this
No, I am not.
and use the judicial proceeding in this manner, then you have
My lord, while police submitted a final report, my lord, and trial court has taken cognizance of that, my lord.
whatever.
So it is not fault with me, my lord. One final report submitted against them, but the FIR is
This
not.
is very, very dangerous proposition. Anyway, let us.
Yes, my lord.
Okay.
Item 15. Item 15, may I please, your lordship. Here, my lord, the petitioner filed this application for the quashing of criminal proceeding. My lord, on the ground there, the petitioner named the Nirmal Raut has not appeared in my lord affair as well as my lord charge sheet. When my lord petition not name also not taken by the cognizance of the learned trial court, and even my lord in the injured statement, injured has not stated anything about the present petitioner Nirmal Raut. But difficulty is that my lord in charge sheet, my lord.
What do you want? Quash criminal entire proceeding.
My lord.
What is the you are Nirmal
Raut.
Nirmal Raut.
My lord.
And what is the charge sheet against you?
Charge sheet, my lord. Charge sheet not filed against me, my lord. In the preliminary charge sheet, the offenses under section, my lord, 341.
If the charge sheet is not filed, why have you come?
My lord, but in brief of facts, my name is appeared. In charge sheet.
You are not charge sheeted.
No, my lord. But under section 1738, my lord, charge sheet is open.
Let it come, then we'll see. Why unnecessary inviting problem?
My lord.
You may be cited as a witness also.
No, my lord. They stated in brief of fact that I have informed that crime.
Brief of fact they might have written, but now so far as today's charge sheet is concerned, you have not been charge sheeted so far.
My lord.
Wait till the charge sheet comes. Who knows that you will be cited as a witness also?
My lord, the honorable coordinate bench, my lord, so pass the similar order, my lord, you can see.
What similar order? Facts are different in criminal cases.
In my lord,
merely because your name appears.
My lord.
173 is open. So how can I scuttle the investigation at this stage?
No, my lord,
merely because your name somewhere appears.
My lord, I humble prayer, my
and
lord.
You are not even an accused even today.
My lord, I humble.
Yes, application, my lord. The coordinate was also taken same view.
Obviously.
Coordinate not find passenger.
When are you going to file the final charge sheet? See, what I'll do is, I will simply adjourn for a longer day. If meanwhile they file charge sheet and include your name,
my lord,
then you amend the petition and challenge.
All right.
That is a better idea.
Obligation.
Okay, I'll simply adjourn it.
My lord.
Wait till it may so happen that you will not be made an accused. Then this is infructuous, you will withdraw and
my lord.
Happy. If they'll make you an accused, then you press this petition.
My lord. But my lord, one I has been filed for the no course, my lord. If he appeared that he will arrest.
Simply adjourn to April. Don't say anything further. You will invite problem. You are not accused today. Why are you?
Since my lord 1738 is open, my lord. That is why he will arrest.
So then I'll stop investigation.
No, my lord. Only code, no course in my lord.
You go 438 is there.
438
If you are so apprehensive, 438.
Okay, my lord,
Reject the
let's see,
application.
let's see me simply,
Reject, it is already
let's see
rejected.
me simply adjourn the matter.
I am simply at
My
that,
lord.
so it is for better. First week of April you give. 3rd April.
My lord, much obliged.
Meanwhile, let us see.
My lord.
They may not charge it to you also.
My lord.
Yes.
16.
May I please also? Petitioners, my lord, therefore passing proceeding on the ground of mutual divorce has already been allowed, my lord.
They have settled.
Yes, ma'am. Mutual divorce is already done. Let's can see annexure.
No, mutual divorce is all right, but
Yes, ma'am. There is a affidavit on the part of informed, my lord. Let's kind of page 29, my lord. Running page 29, my lord.
29.
Yes, madam. So yeah, they file a joint affidavit to withdraw all the pending cases, madam.
All the pending cases.
Yes, madam.
Yes.
Page 20,
Okay.
para 6.
Before the family court.
Yes.
Yes.
Will she come?
No, madam. Let's my notice, madam.
Okay, issue notice to this is the petitioner is praying for washing up for the proceeding pending before learned CJM come ASJ Nayagarh in PS case number 157 of 2015 corresponding to ST case number 77 of 2023. Full stop. This is a case arising out of a matrimonial discord. The petitioner submits that after the settlement arrived between the parties, the petitioner had a petitioner and opposite party number 2 had applied for petitioner number 1 and opposite party number 2 had applied for divorce by mutual consent under section 13B of HMA Act, which has already been allowed.
Yes.
Before the court below, in the 13B proceeding, the opposite party number 2 had filed an affidavit which is placed on record, wherein she has stated that she is not willing to prosecute the petitioner in the in the FIR subject. Issue notice to the opposite party number 2 returnable next week.
Yes, it is Nayagarh, my lord. Address of the note to Nayagarh, my lord. Take time, my lord.
Next week, if she comes, it's all right. Otherwise, I'll pass. She has given the
Yes,
affidavit.
yes, ma'am.
8th. Process fee and all, you file. You cross.
Yes.
You try. Tell her if you have a good relationship. Tell her to appear through VC.
Come, my lord.
No,
That's my the IF for further question.
Next week, I'm
Yes,
giving
yes.
that is the reason.
Yes, ma'am.
Request
Yes.
Article 70.
May I please, your lords. Here, my lord, I am challenging the order taking cognizance, my lord. On the ground, my lord, is the case under section 138 of the NI Act, my lord.
Yes.
Lordship, the magistrate, my lord, taking the
You are the accused.
my lord.
Hmm.
The magistrate taking cognizance on the basing on the my lord, documents filed by the complainant and the affidavit, my lord. Here, my lord, the document list of documents cited by the complainant, one of the prime document, what is the agreement, my lord, that has not been till date and not been on the record, my lord. The similar fact, similar, my lord, the issue, my lord, this court has passed in one case, my lord, as reported in, my lord, 2018.
But why cognizance order? He has to see the content of the complaint and do it.
No, my lord.
If he is not relying
No,
upon
my
some
lord, that-
document, you will get
That, lordship, for a moment, lordship, kindly see the judgment, my lord, that the court say, my lord, since it is a documentary evidence, my lord, it is the duty of the magistrate, my lord, to gone through the entire, my lord, records and the documents cited by the accused, by the complainant, my lord. Thereafter, prima facie satisfaction, my lord. And absence of such document,
In paragraph 9 of the complaint, they also not dispute that those documents were not brought to the court. What was the fact of this case?
fact of the
Check
case,
was issued in
My lord.
of what?
what, my lord, check was issued, my lord, as stated by the complainant, my lord, for the business purpose, my lord. Hand loan of,
In this case-
hand loan of 7 lakhs, my lord. That is the case of the complainant, my lord.
And loan of
Hand loan, my lord.
And there was an
They
agreement.
are on the agreement.
Where is the complaint copy of
Complaint copy, my lord, annexure, my lord,
Which paragraph?
my lord. Annexure 2, page 16, my lord.
As in terms of agreement dated 30th September 2021.
My lord.
What is this case?
Brief fact is page 18, my lord.
I read it. Page 16. I read it.
Page 16, the my lord, the formal paragraph, but page 18, the fact, my lord, narrated, my lord.
Document evidence and when complainant is mentioned regarding some document complaint petition. The position of offenses against man, he has not filed same state without show me the list of documents.
Let's see list of document, my lord, the page, my lord.
Yes.
Page 21, page 21, my lord. 6th, my lord.
What is the reply given by you on to the notice dated 23/11/2022? Statutory notice reply. Have you replied?
Just
You have not
No.
replied.
no, my lord.
You have not replied.
No, my lord.
Then presumption operates against you. What to do? The judgment will not help you.
I take note some time, my lord, because maybe no instruction, my lord, regarding that matter. Whether
If in a 138 proceeding, if a statutory notice is given, you have to reply. You don't reply, then the presumption operates.
some adjournment,
It's one fact.
I'll take
And
it.
second is, insofar as that case is concerned, the entire case was depending upon document. No document was filed.
No, no.
Here
only-
he has filed many documents
No, my lord,
except one document.
no, my lord, one
And he can
document.
substantiate his complaint through the document which he has filed. How
No
can you
document
presume
has been
today
filed by the
that
complainant.
minus that particular document?
That is a
the
particular,
case?
not one particular document, not entire document.
No, just see page 21. What he has filed, bounce check he has filed.
No,
That
that judgment, I am relying,
legal notice he has filed,
my lord.
and the consignment, the receipt, the notice served to you, that is also filed. Copy of account statement he has filed. Agreement made between the complainant and accused, that is also filed. And any document further he will file later on.
If there is no dues, my lord. So that
And he says agreement made between the complainant and accused,
accused, my
that
lord.
he has already filed.
No, no, my lord, that agreement is not available in the case record. That's why I come before your
But
lordship. That-
he is relying upon that.
Your lordship call for that photocopy of the
No, no,
record,
I
my
will
lord.
not call for it. This is, you don't have a case.
Yes, yes, your
You-
lordship.
That judgment will not support him. You
Only-
think over.
That reply letter, I will, my lord, some
In
only
reply, he is the only argument that he says that the agreement between the parties,
my lord,
that is not filed.
my lord.
And in the list of document, he says that
He
document
has
relied on.
mentioned, my lord, but that document is not on the record, my lord. Basing on which he is claiming his entire dues, my lord.
In the pre-summoning evidence, he will bring all these things. He is relying upon this document.
But if the document not filed, my lord, then subsequently how, my lord, it is been accepted, my lord.
He has right to file pre-summoning evidence.
But if he is prepared in
This
another
is the complaint.
my lord.
The complaint. It is not like a suit.
My lord.
He can't introduce document of any sort. But here this is a complaint.
Yes.
He is relying upon all these documents that might not have been filed, but in pre-summoning evidence he'll file it. What is the big deal about it? When was the complaint?
My lord, complaint, my lord.
You better withdraw and prosecute it. Unnecessary. Why are you inviting all this?
My lord, that only one, my lord, that document will be relevant. If there is no, my lord, reply, then I have no case, my lord.
I'm just disposing it up, saying that all these contention are kept open to be decided at the appropriate stage. Okay. learned counsel for the petitioner seeks indulgence of this court, indulgence of the court for quashing up the ICC case and the quashing of the entire proceeding pending in ICC case number 2 of 2023 and the cognizance order dated 10/8/2023 passed by the SDGM in the complaint case under section 138 NIA initiated by the opposite party number 2. The sole contention of the petitioner is that the basis of the complaint, the case of the complaint hinges upon a document, namely the agreement between the petitioner and the opposite party number 2, on the basis of which he has issued the check. He relies upon the next. What is that? He is relying upon a judgment of the coordinate bench in the matter of so, wherein the coordinate bench had passed the entire proceedings on the basis that the relevant document was not placed before the court, and the trial court had taken cognizance in that matter. Particularly in that matter. However, perusal of the complaint indicates that the complainant has relied upon many documents, including a document at serial number 6, that is the agreement made between the complainant and accused. Full stop. That apart, the complainant has also filed many, has also relied upon many documents as listed in the list of documents. Therefore, the judgment cited by the counsel for the petitioner may not come to his aid. Next, having said that, the point raised by the petitioner, the petitioner may raise this point before the court below at appropriate stage, and this proceeding, according to me, is premature in nature. Therefore, the petition is dismissed with formality.
Not disposed of, not
Disposed of by the yes.
18. May please be notes. The order of cognizance.
Yes.
The order of cognizance dated 22/2/2023.
Yes.
Of the ACJM Special Cuttack Milord for alleged commission of offence under section 276B of the Income Tax Act, Milord.
Yes.
The subject matter before your lordships, Milord, in this criminal revision.
276B.
276B, Milords. I have
Yes.
quoted 276B in my petition, and if your lordship would kindly,
Yes. Which page?
Milords, page 8, Milords. 276B, Milords.
Yes.
Failure to pay tax to the credit of the central government under chapter 12D or chapter 17B. Section 2.
Have you now deposited
Milords, I have already deposited with interest.
with interest?
Milords, that is, your lordship
How
would
much
get it.
delay?
Milord, your lordship may kindly turn to page 19.
You
It
simply
reads,
say how much delay?
Milord, delay, Milord, the maximum is 1 month. And there is a considerable delay of 89 days because of the COVID period, during the COVID period.
You have paid the complaint.
I've paid.
Unnecessary. That, what do you want?
No, but I have no opposition by that. I am.
They paid the penalty and everything. Why are you burdening the court? I will quash it, finish it up. These are small compoundable offences.
My lords.
En masse, these are compounded. En masse, they are compounded. The very fact that he has come to 482 court they, deserve relief.
Page 19, I have given the details, my lord.
The delay is only 1 month or what?
My lord, your lordship may kindly turn to page 19. 19, that is my show cause. 30 days.
19, huh?
Yeah, my lord.
Yes.
30 days, 29 days, 30 days. There's no delay so far as July is concerned. 1 day, August, 0 days, September.
When
1 day,
that-
1 day, 1 day.
19, huh? 19,
Page 19. Lord, you got it?
Yes.
There's a table, my lords.
Maximum delay is.
Maximum delay is 89 days. That is for COVID, my lords. That is for the period.
This TDS you have deducted from the salary.
My lords, I am a transporter.
Okay.
So I've deducted from the payments made to the agents, my lord.
Agents. Go. The petitioner has filed these present petitions seeking indulgence of this court for quashing up the prosecution initiated against him. The company or what?
Sorry.
This is against him. Against him.
Individual.
Against him by the opposite party in 2CC case number so. The prosecution is launched against him under section where is that?
276 capital B. Capital B.
Capital B.
And they've taken cognizance of 276 double capital B, but that is only for company.
And cognizance has been taken under section
276 capital B and 276 BB.
2 section BB, capital B. The senior counsel appearing for the petitioner has pointed out, has taken me to the show cause notice, which show cause notice under section 279(1) reads with section 276D small a of Income Tax Act, income tax for the financial year FY 2019 and 20, which indicates that there are delayed in deposit of the TDS amount deducted by him from the payment due to
Made to from the
made to
from the payments which I have made to my agents, my lord.
made to the agents. The maximum delay as indicated in the show cause notice dated 12/12/2022 is 89 days due to COVID.
Right.
The senior counsel further submits that he has deposited the TDS amount along with the penalty.
Along with the interest.
Along with the interest, sorry. Along with the interest. Penalty is also contemplated.
Penalty is not leviable, my lord. It's only interest.
Interest only.
Interest only under
some 10% or something.
my lords, that is 201 bracket 1 capital A.
With interest. So therefore, the offense remain to be tried is merely a technical offense. The so-and-so appears for the opposite party on advance notice and vehemently oppose the prayer made by the petitioner. He submits that non-compliance of the provisions of the Act attracts the offense under section 276B. Therefore, the trial court has rightly taken cognizance. Full stop. 1 day to maximum 89 days
for COVID.
Owing to the difficulty faced by him during the COVID period. I am of the considered view that the prosecution launched against him deserves to be quashed. Next, accordingly, the proceeding so and so is quashed.
Your lordship, may just one small correction that 12/12/2022 is my reply to the show cause.
Yes, I reply to the show cause.
That's 12/12/2022 is the reply to the
show cause.
Manage.
Indicates
Manage.
the delay.
Manage. Greatly obliged, Manage.
Yes, next. Yes, Mr. Naik. He is speaking from somewhere. Hmm?
headphone खराब है.
You remove your headphone and now speak. Take it out. Take out the entire connection.
Madam, this is regarding
Yes.
challenge the order of cognizance wherein the other co-accused persons are left out from the purview of cognizance.
You are speaking from where?
Madam, from my residence, I am not a.
Where?
I am at Noyagar.
Nayagar. Okay.
Yes, madam. I am
Yes.
not a will. I have not gone to Kottago.
No, it's all right. No problem. Tell me.
Madam, co-accused persons are left out for the purview of cognizance, though there are ample evidence both in the FIR and 161 statements. Basically, upon the charge sheet submitted by the IO, that wherein the co-accused person are left out, excluded from the charge sheet, and basically on the law and court below has taken the cognizance, simple accepted the cognizance is taken without any verifying the records. There is no.
Where is the cognizance order?
Order, I mean, what a page 31.
Yes.
Page 31 and extra 4.
Ananta Das. Who are you? Ananta Das.
Cognizance is taken.
You are
Osanti Sethi is the informant. Informant.
I
informant.
am informant.
Go and file the protest petition.
Ajay, you okay? Okay. You say that the other people are left out,
Yes, similar.
and the against the charge sheet, letting them off. Have you filed protest petition?
No, protest petition, no, I am not filed, my lord.
That is the procedure. You are the complainant. You
I'm
made
also
complaint against 3-4 people, and after investigation against one person, the charge sheet is filed. You are aggrieved. Then you file the protest petition instead of 482.
Offline no manuscript permit me observe and dispose of the case. I will file a petition.
The law has already permitted you.
Oblige me.
Law has
Oblige.
already permitted.
Oblige.
Petitioner seeks to withdraw this petition to prosecute his remedy under CRPC. Under the CRPC, accordingly, the petition is dismissed as withdrawn with the liberty as correct.
Dispose of.
Yes.
Dispose of. Would not dispose of. Oblige.
Okay.
Oblige.
20.
Item number 20, Your Lordship. 107 proceeding was initiated against me without done any proper inquiry as per the section 116 of the CRPC. And there is also judgment of Madhu Limai versus Ved Murthy. It was.
So Madhu Limai is all right. What is the case?
The case is there is a land dispute between the two parties.
107 and show cause notice, you go and appear. What is the big deal about it? Why 482 for that?
Your Lordship,
You
we
go
have,
Madhu Limai, you say all constitution bench judgment, right from Keswanand Bharati to everything. 107 notice is issued. Why are you coming to the court?
So cause file kare go and sign.
Show cause notice, you appear.
Lordship, we have filed a show cause.
Anyway, what do you want to see? Tell me.
Lordship, earlier I have filed that this CRMC number. P582 of and in that order the court has directed to file the show cause. And we have also filed the show cause. Earlier in the surveillance, but they are माने सेमान हमको धमको जोन डरो जोन कि आम ऊपर सेटा ये कर दे तो सही जो काम है CRLMC फाइल करके
So cause को दे जो कौन order है?
Where is that order?
32 page. 30.
Page number 33.
You came against what in this matter?
I came against Your Lordship the notice.
The same notice.
Yes, Your
Same
Lordship.
thing,
Same thing.
show cause reply, this court finds no reason to interfere with this stage in the
Because notice, why are you coming? You came once, the court said the same thing, again you are coming for the same thing. What can I tell? The same thing. What to do?
Well, also we'll file show cause.
show cause
What?
file.
Huh?
Show cause file.
Show cause
court
file.
detail.
File, super.
Your Lordship, I will also filed an IA.
Challenge the challenge the what is date with nothing is there. 3/8/2023, huh? 3/8/2023.
3/8/2023.
Notice dated 3/8/2023 issued by the Executive Magistrate Tirthol, calling upon him to show cause under section 107 CRPC. So called under 107 CRPC. Then comes for the petition submits that he would furnish the he would submit the show cause and participate in the proceeding.
Already
Yes.
participated. Already
Huh?
participated. But he has filed a time petition to file the show cause. Time petition were allowed.
So, and doesn't want to press this petition
Yes.
at this stage.
Yes.
It is disposed of as withdrawn. 21.
May I please, Your Lords? My Lord, the order dated 17/4/2023 for passing up an NBW against the present petitioner. My Lord, the fact is that
What is the offense? Forget, bro. So,
my Lord, if
bail
the,
granted?
the order dated, my Lord, 17/4/23. My Lord, case is that the present petitioner initially had a love affair at the present of a girl.
That apart.
On that case,
Now NBW is issued. You are on bail or not?
no, my Lord, that is my case is different. My bail has been cancelled, violating one condition. The Bijapur PS case number 81 of 21 was initiated against me regarding the misbehave to the girl with whom I have love affairs. That in that case, Lord and Court below allowed me on bail. Again, the girl eloped with me.
Second time.
Second time. Another case was registered.
Same girl.
Same girl. For that reason, Lord and PP filed a petition before the Lord and Court below that he has committed another offence. In the first case where I was on bail, there is a condition that you should not that they'll
You should not indulge
Commit-
in the same kind of offense. or not.
for that reason NBW was issued against.
Whatever NBW is issued,
My Lord.
you go and surrender. Simple.
Well, the same girl. And it is a case of elopement, my Lord.
That's right. But what 482 court can? I can only at best I can stay the execution of the NBW till you surrender and take appropriate
Recourse.
remedial. I can't do beyond that. That is what I have been doing. The only one more this thing is I will not impose any cost because you whatever.
My grievance is same girl, second time elopement. The Lord and Court below also was pleased to grant me bail.
Counsel for by way of this petition, the petitioner is seeking quashing up for the order dated 17/4/2023 passed by ADJ cum special judge so Jajpur in city case so and so Dedra. Page 5. Okay. Whereby NBW has been issued against him. So, counsel for the petition next part. Counsel for the petition submits that he was prosecuted in which case?
Well, Bijapur PS case number 81 of
He was
21.
earlier prosecuted in Bijapur PS case number so and so 81 of
2021.
21 with an allegation that she has
Misbehaved.
sexually harassed the minor girl. He was granted bail in the same case with the condition that he would not indulge in such case. in future, in future. In future. However, the petitioner had eloped with the same girl once again, once again, full stop. Therefore, the IO had moved an application.
Then I'll not PP.
The PP had moved an application, for having violated the bail condition in the earlier case. Full stop. In pursuance thereof, the NBW has been issued against him.
Bail was cancelled
By
and
way of the
NBW.
impugn order. Huh? By
Bail
way-
was cancelled and NBW was issued.
Bail was cancelled. Bail was cancelled and NBW was granted against.
Yes.
Full stop. Next, he submits that he would appear before the court below on or before 20th of February 2014, 2024, and seek remedy available to him under law. Under law. Next, taking into consideration the aforementioned peculiar facts of this case and submission at the bar, the order dated, which is that order?
17/4/20.
17/4/2023, in 23 is kept in abeyance till 20th
February
2022.
24.
2024, and the petitioner is directed to surrender before the court below and avail remedy is applicable to him under.
Yes.
I kept in abeyance this much protection I have given because he is in love with that girl, so young stress, so therefore I have given.
Am I allowed?
20th you
good.
go on, sir. 20th you will not be upset.
ନାଇଁ ମୁଁ 28 ଭିତରେ ସରେଣ୍ଡର
You
କରିଛି
surrender and get a bail at least.
ଟିକେ sympathetic view ନେବେ ସେତିକି taking into consider the love affairs between the victim girl and the
That I laid somewhere. But the counsel for the petitioner submits that his client is in relationship with the victim girl. Okay.
22, my lord.
Looking into the age only I have given because they are youngsters. This unnecessary.
Yeah, enjoy karo.
Yes.
My lord, NBW has been issued on
Which item?
22.
20? 20. Okay.
20.
Going slow today.
And in the meantime, that lady was all along in bail, but due to some multiple.
You are on bail.
My lord, NBW has been issued against once joined the London. She was well and happy and was a regular attending. All of a sudden, my lord, she suffered from multiple problems, which a doctor said with there.
That's right, but you were on bail or not?
Previously,
That's right, obviously.
Previous bail agency.
Which court is? Which is the order issuing NBW? Where is the order?
My lord, order
2/8/2023.
My lord.
Where is that order?
ଆମକୁ ଗୋଟେ କପି ଫପି ଦିଅ
My lord, NBW has been issued by page 8, my lord. Page
2/8/2020. Where is that order? Impugn order you have not filed. Where is the impugn order?
that page is the impugn order.
See, what is this? I don't understand.
Actually, this case
you have
has
not
been-
filed the impugn order. Where is the annexure?
This case has been listed only because to remove the defect. This case stands adjourned to 21/2/2020.
See, you have not filed the impugn order. How will I?
Impugn order was there in that file. That file I can show you, my lord.
I have to see this file which is there with me.
File.
Not that your file. You file the impugn order, then we'll see.
Impugn order, my lord, is there, my lord.
Where is that order? Is not there with me. Just see.
Annexure 1, well.
Annexure 1 is some medical document. Only medical document. Page 8 is also a medical document. Page 7 is also a medical document. Annexure 1, you have just see Annexure 1. Show the files. Which page?
But page one, page seven. Page seven, my lord.
Page 7 is a medical document in my file.
Not medical document, my lord.
আরে সেটি যোଉটা আছে সেটা পেজ
I have seen this. No?
কোর্টଙ୍କର ଯୋଉ
So that is the reason there is a defect. You cure that defect. You cure the defect so that the
Defect or defect.
something which is not there on record. What can I
My
do?
lord, defect has already been removed.
Just check it up here. Coordinate and put it day after tomorrow. We'll see the scan copy and that copy. You'll check it and
Bye.
yes. Next.
23.
Yes.
My lord, the petitioners are accused in Bolangir Sadar PS case number 148 of 2019 for alleged offences under section 341, 294, 323, 325, 34 IPC lordship. After registration of this affair, they obtained bail from this honorable court and some from the London session judge, your lordship. That is the
It's all right. Now,
annexure 3, your lordship. Here the problem is the charge sheet has been filed on higher offences. FIR registered on
what is the aggravated offense added?
307. That is the trialable by court of sessions. Although the
307, see, I tell you, because that Susila Devi and all,
yes,
it is extendable. That the regular bill you got. in
I
other
have,
offenses.
I have got regular bill. That is page, your lordship, page 27, that has been mentioned by the Lord Court. Your lordship. Kindly see the
That's right.
accused persons, Ghanshyam Sahu and
So yeah, Mr. Maharaj,
my lord.
according to me, see, I'll tell you,
No,
if during the investigation, if somebody has got bail, anticipatory bail or regular bail, whatever,
my lord.
and after investigation, you file the charge sheet adding an aggravated offense.
yes,
So according to me, that bail suffice, because for the simple reason that during investigation, if somebody is not required, you don't need custody. You don't need custodial interrogation because you have filed the charge sheet. So therefore, he is entitled for bail.
no, that is the
Why do you need this custody now?
decision, my lord. The decision of the Susila Agrawal, it is clearly stated and clearly observed that once higher offense is added means he has to approach once again before the court, concerned court, as per the provision. I'm reading this exact.
Read that paragraph.
Yes.
Read that part. But if his custody is not required, he will face the trial. What is the big deal about it?
সেটা হবনি।
Show me which paragraph.
302 যদি ହେଇଗଲା କଣ ହବ ପୁଣି?
302 ହେଇନି ଏଠି, ଏଠି 307 ହେଇଛି।
You don't.
ଯୋଉଟା ଯୋଉ କେସ୍ ସେଥିରେ
In
କହିବ
this
ବୋଲେ
case,
ସିନା।
in fact of this case, you tell me.
ବାବୁ ଯାହା ଯାହା ଆଇନ
ହଁ।
ଅବସ୍ଥା ଅଛି ମୁଁ ସେଟା
ଯେ ଅବସ୍ଥା ସେ
No,
ଅବସ୍ଥା
show me that judge,
ଆଜ୍ଞା ମୁଁ ସେଇଟା
that
ଦେଖୁଛି।
part of the judgment.
Lord, so I have also one judge.
ମୁଁ ଦେଇଦେବି।
Here the case
That
has been
judgment?
registered under section 306, FIR registered under section 306 and charge sheet under section 304B.
No, Susila Agrawal, the Supreme Court now has
Just
taken that.
or this.
In that, Susila Agrawal, the court was examining the fact that what is the life of an anticipatory bail
Hello.
order. There they have said something.
My lord, exact point I'm reading.
Yes, read that.
Everything has been discussed. It's a judgment of my lord before Honorable Justice Bineet Saran, M.R. Saha and S. Ravindran Bhatt.
Yes.
Three judges, larger bench.
Ravindran
Yes,
has
larger
said
bench.
it. I know that.
And,
Read that
and
paragraph.
this important things has been given
Paragraph read.
findings.
Hmm.
The anticipatory bail granted can, depending on the conduct and behavior of the accused, continue after filing of the charge sheet till end of the trial. Also, order of anticipatory bail should not be blanket in the sense that it should not enable the accused to commit further offences and claim relief. It should be confined to the offense or incident for which apprehension of arrest is sought. In relation to a specific incident, it cannot operate in respect of a future incident that involves commission of
Future incident
involves
which is
an-
separate from the incident.
no,
concerned.
that involves
Not that
commission of offense.
the idea of that judge sentence is if he has taken anticipatory bail, if some other offense is there, it will not covered. but pertaining to the same offense is aggravated sections you have added. That bail suffice.
Like when the affair has been registered under a minor offense, then during course of investigation, he has granted anticipated bail.
Yes.
The future, one cannot say in future what will happen. After completion of investigation or during course of investigation,
I will qualify what you say.
Yes.
You say had it been 302.
Yes.
If 307 is added and he has applied for bail, he got the bail.
Yes.
He could satisfy the court that he is entitled for bail under 438 in 307.
Yes.
Suppose that victim dies. If he is entitled for 307, then prima facie case is there that he was not involved. So 302 also he is entitled.
Lord, for
Because
that,
incident is same.
my lord, for that remedy there under section 437, they can move for cancellation of bail if any term and conditions or anything has been violated, your lordship.
That is a different story. What does it say that according to the petitioner, bail once granted inoperative during the whole gamut of the trials, and it cannot be granted in installments. So then comes for also. An order of bail dated so on so on so for. What is the added offense?
307.
What is the injury?
Lord.
Show me the injury.
And 1 second, your lordship. Another point. Both the section 437(5) and 439(2) empowers the court to arrest an accused and commit him to custody who has been released on bail. Under chapter 18, there may be numerous grounds for exercise of power under section 437(5) and 439(2). The principles and grounds for cancelling a bail are well settled. But in the present case, we are concerned only with the aspect of the matter.
Anticipatory bail.
A case where after accused has been granted the bail,
Yes.
new and serious offences are added in the case. A person against whom serious offences have been added, who is already on bail, can very well be directed to be arrested and committed to custody by the court in exercise of power under section 437(5) and 439(2), cancelling the bail granted to an accused and directed him to be arrested and taken into custody can be one course of action which can be adopted while exercising power under section 437(5).
437(5) is cancellation.
No. ଯେତେବେଳେ added ହଉଛି ସେ offense କହୁଛି ଯେତେବେଳେ added ହଉଛି offense.
Then you have to once added, you should move application for cancellation.
My lord, that is
You have not done that.
That is the procedure, your lordship.
ସେ ତ
If it is added, immediately you would move application
My
for
lord.
cancellation.
After submission of charge sheet, your lordship.
ତାକୁ ସେଇଟା କହୁଛନ୍ତି.
After submission of charge, they can move on.
I'll keep it on. See, this matter is being argued in other
Yes,
courts
yes,
also.
yes,
But my prima facie view is he's entitled for bail.
ସେଟାରେ ଆଦେଶ ଦେଇ ଦେଇଥିଲେ ଆମେ କିଛି କରିନଥିଲେ. But it is
And there is one judgment is citing this judgment is also direct.
My lord.
Direct on the point. Then shall I keep it on 19?
yes, yes, Lord.
I'll keep it on 19.
Yes,
You get 19.
Yes.
My lord, file a petition for stay of further proceeding because 22 January was
The
the
bail matter, whether you are entitled to bail or not, that I'll decide. I'll stay the proceeding.
my lord warrant will be issued against me. If
No,
you
19th what will happen? Nothing will happen.
22 को थिला.
If warrant is issued, come and mention. I'll take up on the same day.
My lord,
You come and mention in the morning, I'll take
my lord,
up on the same day.
my lord.
Okay.
24.
At 24, my lord, due to non-appearance, my lord, no steps was taken. NBW was issued on 7. My lord, page 7.
You are on bail.
Yes, my lord. Notice was issued to the
The bail,
my lord.
when the bail?
My lord, bail, by the court below has on bail. It has been date and then, but on bail. It has been mentioned that notice is also sureties on the
22, the NBW was issued.
5/9/2020.
Today you are
No.
coming.
No.
1000. 22, sir. 2 years.
5/9/2022.
Therefore, 1000. And
500.
you are appearing.
500.
If juniors would appear, you are appearing, so that's what 1000.
Yeah.
1000 bar only you are paying bar. What is it?
4%.
Chalo, 500. So, Okay. Yes.
25.
Yes.
One capital I pray. One capital.
Okay.
26.
The same type of case.
The question of proceedings.
Only. Easy brief everybody can argue. Yes.
May I please, Your Lordship?
Yes.
Well, this is a peculiar and interesting case.
Hmm.
Blood.
Your presence itself is indication of that. Yes.
But the petitioner is a police personnel from Bangalore. He was interested, my lord, a team of my lord police personnel were interested to my lord investigate an offence under the NDPS Act. And the occurrence was in Bangalore, my lord, under the Jigani police station. So he is a police personnel from the Jigani police station. And during investigation, my lord, early stage of investigation, it was found out that 2 people from Odisha are involved in providing ganja under the Jigani police station, and ganja was being sold to the college students.
Ganja goes from
Orissa to Bangalore, and there it was being sold to the college students.
Yes. How are you involved there?
So that is very interesting. I was the one of the police personnel in the same police station. Then a team of 5 police personnel was constituted to find out the route.
In Bangalore.
From Bangalore, a team of 5 police personnel was constituted.
They came to Orissa.
They came to Orissa to find out the route.
And the complicity of yours is
yes
established there.
Well, when I came with the team, Malad.
You were also a part of the team.
Yes, I was a part of the team.
Of that 5 members.
Yes.
Okay.
All the 5 members, they came to Orissa, and they divided Malad themselves into 2 groups. And there was also a person from Bangalore who could Malad who had Malad knowledge in both Kannadi and Odia. A translator. So 3 people, they remained 1 kilometer away, and 2 people, along with the present petitioner, they were to locate the route from Odisha. 2 people, namely Subhash and Naresh. And then a place was, plot was fixed, and they were called, and they brought ganja with them. And this police personnel, then he caught hold of the 2 people and about to move to the local police station for information. Coincidentally, a local police patrol van, they were passing by, caught hold of this man, this police personnel, by saying, as if I am involved in that. There was a communication between the local police and the Bangalore police.
Earlier it was communicated to the
Yes.
local police or not? Your
Yes,
presence,
yes.
Your presence was entered in
Yes.
the...
And thereafter, the local superintendent of the police, with IPS officer, he has another IPS officer friend in Bangalore, contacted him, and it was communicated that yes, he is the police personnel, has gone to find out the route of the ganja. Despite that, he was arrested. And this honorable was granted him bail. Now I have come for quashing.
Granted bail?
Yes. Now I have come for quashing. As far as he is concerned, there are section 69 immunes. Lordship may kindly see section 69 and under section 48 of the CRPC ballot. In a cognizable offence, I can arrest any person, a police personnel authorized can arrest any person inside the country. And I was bestowed with the power under section 48. I was included under section 69. How could I face the murder? And then what will happen? Yes, and Lordship may kindly see and look at the severity of this particular action. Anyone going from Odisha, any police personnel to Bangalore, will have a same fate.
The problem would be only that at all this court will interfere at this stage.
Yes.
The court has to form the opinion that the facts which you are narrating
And
is correct.
I can
So
demonstrate.
how will I ascertain
But
that which you narrate
yes,
is correct?
well, I am demonstrating the fact by producing material. Bangalore police, Odisha police communication. Framing of the team coming. And the fact of ganja being distributed in Bangalore, route being in Odisha. Everything on record.
Let us see 60.
Lordship may kindly see section 69.
This was the first visit of yours?
Yes.
Earlier you never
No,
visited?
never.
No?
Yes.
What is the material on record to suggest that you were with these two people, Subhas and all?
Yes.
Had you communicated earlier?
But that is what the documents are filed. I'll just take a lordship will just see.
If you had earlier communicated with Subhas
Yes.
and the
Well,
other
what normally happens?
then you have a complicity.
Yes. No, lordship may kindly see. What happens here is, even the permission is granted by the 8th additional district judge.
All these things are correct. But
Yes.
what was the occasion for you to contact these two accused along with you
No, no.
before you started
Let us
trading?
find out the route. Lordship, everything is narrated by lord. Lordship may first see.
You knew these people earlier.
No, not that is the reason I had come with another person. Well, who and also
Do
one.
you have any material to show that this gentleman
the-
was in contact
Yes.
with Subhas and the other
Yes,
guy?
let-
Your
yes.
Lordship may kindly say. Okay, very common sense. We should not go to the law. First we apply our-
Common sense is always uncommon.
The law is always common sense, my lord.
Yes.
My lord, your Lordship may kindly see the accused who has come for an investigation in connection with a particular case. He has not informed the local police. Number one.
But he says
He is not a officer. He is a constable, as he has alleged. He is a constable.
Okay, that's
And if your team has come up, then
headed by
whom?
Yes,
My lord?
out of
Yes, you have been
who are heading the
arrested.
team?
Lordship may
You
just
should have you should have proved yourself by providing the document before the police.
No,
what
And
is
you are
saying,
holding the ganja.
So we are examining one issue that if at all, if their bona fide police officer came for investigation,
Lordship just sees
and
page 27.
due to misunderstanding, we just examine whether due to misunderstanding he is
Exactly.
or not. That is the only
Lordship
limited
just sees page 27.
So far the materials
some
available.
procedural lapse might be there, but if honestly they have come for investigating an offence, unfortunately due to some irregularities, procedural irregularity not found, and because of the misunderstanding, whether these people are suffering or not. That is
Lordship
the-
just sees page 27, my lord.
Absolutely right.
Page 27, my lord.
And let us see
69.
69.
Yes.
How far you will stress it?
Yes.
No suit,
No suit, prosecution, or other legal proceedings shall lie against the central government or state government or any officer of the central government or of the state government or any other person exercising any power or discharging any functions or performing any duties under this act for anything in good faith done or intended to be done under this act or any rule or order made hereunder.
intended to be done.
Yes.
You may come under that.
Yes. Lordship may just see page 27 now.
27. Yes.
Annex 3, my lord.
Yes.
Lordship with me, my lord.
Appaji ASI. Anand.
Yes. This is office of the SP Bangalore district.
Who are you?
I am Anand, number 2.
Number 2.
Chief Head
All
Constable.
ASI headed by
Yes. And there were
Karnataka State Police so passport. Karnataka State Police. What happened to this CR case number 242 of 2023,
My lord,
in which you came for investigation?
that is pending, my lord. In Bangalore, I had only come in connection with that case only, my lord.
Who all are the accused? Whether these
These two, yes, these two are supplying. Yes, this my lord, Mahesh, Subhash and Naresh.
they were the accused in that case.
They were the people who are supplying to other people. I have filed the FIR also at page 19.
You brought them here.
Yes,
Subhash and-
yes,
Under custody.
yes.
They were under your custody when you
Exactly, my lord. Lordship may just see Sujit Raut and Khageshwar Naik. They were the two people selling in Bangalore, my lord. And the source of getting the ganja to
My
Bangalore.
question is something different.
Yes.
What I'm saying is the CR case number 242 of 23 in Bangalore.
Yes.
You were investigating.
Yes.
And you wanted to know the source.
The source.
Real source.
And the accused persons there, my lord.
Who all are the accused persons? Tell me in that FIR.
Sujit Raut, my lord, at page 20. Sujit Raut. Well, it is actually Raut.
Raut.
But they have written Rawuth.
That happened. Raut and
Sujit Raut, one Sujit Raut, another Khageshwar Naik, both from Odisha.
Khageshwar. Okay?
Yes.
These are the accused in
that case.
242.
Yes, and also two other people.
Case, in your case, where you are the accused, who are the accused?
But in my case, Malad, it is at page 30.
Who all are there? 30.
The accused are
K. Anand, Jayant Kumar Patra, Syam Kumar, Naresh Pradhan.
Naresh.
None of them.
Naresh, the one.
No,
none of them.
Sujit and Khageshwar were the accused there.
मुझे कह दिया ठीक है रुआ तो एमिति ऊपर चढ़ना केमिति हबो just wait.
Yes.
मतलब they are the people who were arrested in that case. So from them also the source could be detected from Odisha. They gave these two names. And
which name?
This Naresh and Subhas.
Show me their statement.
Yes.
In that case.
Not to kindly see Annexure 2 at page 25.
25. Annexure 2. Yes. These are the voluntary statement.
Yes, this is the statement of.
Have they disclosed the name of
Sujit Pala? Not to that's his Sujit statement.
Yes, Sujit.
I live in the above address and work as a laborer. My father, Suresh Chandra Raut, was a farmer in our hometown, so-and-so. And my mother, Srimati so-and-so in Odisha, a daily wage worker. My parents have 4 children. First is Rita Raut, married to Sushant. Well, let me skip over first para. Then second para. I studied up to 10th class of Dayapura village. Then I was not interested in my studies. And my family were forced me to earn something as a daily wage worker in our village. During the work, I have cultivated the habit of drinking alcohol, smoking cigarette, and hanging out with the girls. Due to this, I was unable to support my family and fulfill their daily needs. Then I asked my parents I will work in Bangalore, earn some money after the permission. I came to Bangalore during my Bangalore visit 6 months ago. I met Manoj Damai.
I got it. 26, page 26.
Yes.
He says Naresh and Subhas.
Yes.
Subhas.
Yes.
Pradhan. Subhas Pradhan.
Yes.
He gets the drug ganja from Naresh and Subhas Pradhan from Orissa.
Yes.
And supply it in Bangalore.
Exactly, Malad.
This is the source.
Yes.
And you have been, and Manoj and Khageshwar Naik told me that, I'll check, yes, okay. And you came to Orissa to see the role of these
Subhas and Naresh. Yes. Yes.
Now, so you are FIR, where you are the accused. 30, page 30.
Yes, page 30.
Page 30.
Yes.
Now come to page 30. Page 30. Naresh is there.
Yes.
Subhas is not there. Naresh Pradhan is there.
Yes.
He is the accused number 4. Along with Naresh Pradhan,
Jayant Kumar
Patra and Syam Kumar.
Syam Kumar, who could be a translator?
You are apprehended along with Naresh.
Yes.
Along with all the 3.
Yes.
3. All the 3. Let us see the story little bit. Naresh Pradhan 48. Then in the presence of PM witnesses, research, see the FIR. Read the relevant part of the FIR.
Lakshmi, page 33, Malad.
Yes. With permission of executive magistrate.
Starts from 34.
Yes, respected K. Anand. It must report 5,000 from suspect and contain that to the bag in position of okay Anand where brought out. Wait, what is the recovery?
No ganja, my lord.
Huh?
Ganja.
No, how much?
My lord, ganja around 14 kgs, my lord.
We found to contain the food in that top. Four kg.
From this person.
Carrying weight of 240 grams. Then the presence of your witnesses such as Jain Patro. And so Jain Patro was brought out the bag and found some more. Have you disclosed that I am a
Yes,
police
sir.
officer came for where is that in FIR? Thereafter 4 p.m.
No, that of course they have not stated.
Will be made out against.
But it is there in my lord. Lordship kindly see while section 50 was being complied at page 55.
55.
Yes. It is at page 56.
Yes.
It is learned as per direction of Karnataka State Police, you have visited Kandhamal on a special duty in connection with investigation case number 242 of 2023 of Jigani Police Station. As your activities look suspicious, it is there within the knowledge. And Lordship, most important is at page 66 and 67 and 76.
60?
66 and page 76. 66 is blood. There is superintendent rights to the DG police.
Yes.
Please look into this.
Permission of the special report.
In reference to the above mentioned, not 66 blood. That is Jigani police station case number so and Sarangada police station case number so. In reference to the above mentioned subject and reference, it is submitted before your esteemed authority that on 10th of October 2023, at about 4 p.m. in the evening, Kumari so police sub-inspector of Jigani police station received specific information that some 3 persons had brought ganja in a bag and were trying to sell it near Aishwarya layout at Koppa Gate within the limits of Jigani police station, which she had entered in the station diary. And after informing her senior officials about the information, obtained permission from the Deputy Superintendent of Police, so-and-so subdivision for conducting raid, and then summoned the Panchayatdars and after informing them, conducted raid along with Panchayatdars and police personnel, apprehended Sujit Raut, then Manoj Damani, and third is Khageshwar Naik, and seized 10 kg 70 grams.
Come to page 69.
69, yes.
Yes. 69, last part. A special team was formed.
Yes.
To trace the accused.
Exactly, Valad.
In case, namely Naresh Pradhan
And Subhas Pradhan.
The same Naresh Pradhan is an accused.
Yes.
In this case.
Yes.
Obviously, accused have a problem nahi. Other accused persons are there. And he is found possession in 4 kg and 200.
No, obviously, he found possession because he came to get that only.
Yes.
Because she on the spot. And he did not, he could not able to provide any explanation to that at the time of investigation.
Now, he said that I am a police officer.
Where he has stated, madam?
That is what he said, 55.
This is the affair.
And the senior most police
I am
officer,
reading the affair.
DG police of...
This is subsequent, this is the subsequent document, and I am reading this affair, my lord. And yes, your lordship may kindly see this order.
What is
this honorable court has been passed, this order. Lordship may kindly see. This is the custody bail where this has been observed.
Yes.
A person has been arrested and he is granted bail by this honorable court. This is the
in the same case?
Yes, sir.
Anand, okay.
Same case. And all these things is needed to be proved at the time of trial.
Well, this is
not a case of, it is a not trial court to be proved.
Well, this, I'm sorry to say, it's a preposterous submission.
Affair is very clear.
then my lord, the Odisha police is also not safe in Bangalore. No police will be safe in another state.
He got the bail, huh?
Got the bail.
Oh,
And
that's-
whether
that-
they have informed, he has informed the local police.
My lord, I have,
When he has come up for an investigation, whether he has informed the local police, where that is.
my lord, section 48 says
Where
I
that
can
is?
arrest.
Without informing the local police, how can a person will come?
My lord,
and-
how can once I get them, then I have to go to the police station. I am supposed to go to the police station.
No, first
Arre,
he
come on,
is to be informed, then the procedure will be commenced.
well, let me show that. In this kind of offenses, I have to do that. Oh, what he says, that's not law.
Just see page 69, next paragraph also. This is the letter of the Director General of Police.
And again, sir, the CDR details. Well, what more can I say? The CDR, page 69,
Yes, right.
the CDR details of the accused Naresh was already collected.
That is where I am stuck.
Yes. Call details are there.
Has this officer contacted the accused prior to coming to Orissa? Do you have any evidence to that?
No, he has not produced any document. We apprehended from the spot 4 persons. Individually, all were holding ganja. This person was holding 4 kg 240 grams ganja. He could not able to explain why he was holding this ganja. And suppose my lord admitting for the sake of argument that he is not the accused. His officers will not come to the police station that these are our staff.
And the DG police writes letter to
This is the subsequent document, my lord.
Well, there is the lordship knows that there is a.
What happened to the other 3,
At the time of-
other 4, what do you call, the officers, those who have come?
No, we don't know. That is their
Well, they
plea.
came up and found me in the police station.
That is their plea, my lord. He is to prove.
What their plea? A team of 5 people come my lord, to trace out.
ଆମେ କେମିତି ଜାଣିବୁ ଯେ ସେ କୋଉ ଲୋକ ଆସିଲେ କାହିଁକି ଆସିଲେ ତମ ଗଞ୍ଜେଇ ଧରିଛନ୍ତି ନା ଆପଣ? You are holding the ganja, contraband articles, and you could not explain this before the police.
Let us go into the deep into it. See, this is a case where we should
My lord, the ID card was shown to them, my lord.
examine.
ID card was shown to them.
Officer,
What
higher
are the-
officer will not contact the higher officer of our state. One of our officer is for the investigation and use.
Think it otherwise. If a team of police comes
Yes,
to Orissa,
yes.
they may think that see, we have to cut hold of this Naresh Pradhan because they are hand in glove with your local police.
Yes.
They might not have informed. It is a call taken by the senior most officer of the team. Senior most officer of the team is an ASI.
Yes.
4 a constable came with him.
They did not come to the police station.
The only thing is Naresh, whose name was taken by the accused person there in Bangalore.
Exactly.
We got it from Naresh.
Right.
He comes and cut hold of Naresh.
Exactly.
He had no contact with Naresh earlier.
Exactly.
Show me
my lord.
any evidence that
No,
he had contact with
I
Naresh
am
earlier.
not. I will satisfy your lordship.
Yes.
First, number 1. Yet a team of persons came for investigating a case. One of the person out of the team was arrested by the police.
No, not 1, 2.
Well,
Not one, two.
For money. Well, the other persons.
3 went one side,
Yes.
2 went this side.
Exactly.
Right, Millard.
And
Right, Millard.
yes,
Right, Millard. Accepted it. The person who was arrested from the spot used to explain that we have come up for this institution.
that is what I was searching in the FIR.
And
It's not there.
the next is the team did not inquire that where the other 2 persons left. And when this came to the knowledge of the officers, ASI, the ASI is not duty to inform the police, the
You have
concerned police.
Well, what is he saying, my lord?
You have the
Absurd.
So, got a team asile se
You have the CD with you. You have the CD with you.
No, I am whatever document has been supplied by my lord.
You are on to
That
see
is
the
there.
CD. This is a case
But
where
we don't have.
482 court should interfere. Let us see. Understand?
Yes, yes.
Let us get the CD.
I will get the CD.
Get the CD.
But this is not the case, my lord, where the
Get the CD. There is a because 69 is a draconian law. if a genuine person is there, we have to examine it.
Yes.
We have to give the benefit of 69. See,
Absolutely.
legislators are very careful about it. Why? Otherwise, in a special statute, why 69 is incorporated?
No, 69
Only
is
to
there.
take care of this kind of situation.
Yes.
Exactly.
And if we don't, in 482, if you don't examine this,
Yes, right.
then we are
No,
not doing justice.
that is
So,
absolutely right.
in the light of 69, we will examine the entire CD.
69 is always there, and for 69 is also for us.
That's
69 is
right.
also for us.
That's right.
For us, man.
And we have to inform the local police first.
Right.
We cannot directly enter.
We'll see. I'm not taking an
Independently.
opinion.
My lord, is it 69 for Odisha police, not for Anglo police? For us means for Odisha police.
It is for everyone.
Oh, what is this submission, my lord?
Sometimes it is for lawyers also.
Yes, exactly. Exactly, my lord.
Inform kariban, inform টা দরকার না।
Let us see CD. We'll see CD, then we'll find it. I can't say part has no meaning, but I have spent little time, so therefore I'll put it little
Part had.
quickly. Examine. And Mr. Maharaj,
My lord.
you just examine without being prejudice. Prejudice in the sense he is an accused. Keep that apartment, and in the light of 69, let us examine and try. If any evidence is there, if any evidence is there, is a genuine accused, he has to suffer.
Yeah, exactly.
There is no doubt about it. After
Right,
all,
right.
Otherwise, no police officer who is entrusted with the duty and responsibility
then
will carry it out, my lord.
that is the reason, because the senior most officer of the state is writing letters saying that in these circumstances he is
Yes.
arrested. So please look into it.
No.
Then
On that paper, my lord, I will take instruction. whether
IGF
that-
police central range
Yes.
Yes.
Bangalore is writing.
And that letter, whether it has been sent to our concerned police station or not, that is
you
that is
verify
to
these
verify.
things.
That is to verify.
And we can't throw this letter like this. And then see, I'll tell you one thing. What is happening in the NDPS? Generally, the FIRs are photocopies. Change the name and the people, those who are taking ganja from one place to another place, they are cut hold of those people. And real source is never investigated.
Yes, sir.
And this is the first case where I'm looking at it, at least they are trying to locate the source. And he came to locate the source, and they are in trouble. Generally, what happens? The source is somewhere else. That is never investigated. The people, those who carry from one place to another place, they are booked. None of the police inquire about the source. You tell me your police does it? Your police does it? Your police also don't do it. So therefore, I'm inclined to go into the entire record. At least they started inquiring the source.
Yes.
And came to Orissa to find out the source. And they are in soup.
Let us, my lord.
If they have to file the charge sheet as it is,
Yes.
nothing would have happened. This what is called Sujit Raut and Khagesh Parab
Exactly,
would have been
exactly.
acquitted or whatever. Their job is over.
Yes.
They try to do extra thing to find out the source. Came to Orissa. They are in soup.
Things altogether different.
Where generally NDPS nobody does.
Cases.
And you also don't do.
Yes, sir, that I know what the police is doing, but still, this case is some way
Therefore,
different.
Let us
You
consider
cannot
this case,
easily.
Well, he is as a fixed mind. He is repeating the same thing. He is not oscillating.
No, he is doing his job.
Well, it's not. Well, I don't think it's the job of a state council.
That's right.
It's not the job of a state council.
That way he is very fair.
Yes.
That's the reason I'm requesting to look at the entire file.
Yes.
In the light of 69. And
If it is so, deliberately I am saying today, even I may be resign from this post.
No.
But I must say what is true.
No, that's right.
By taking instruction.
This
is my submission before your lordship.
That's your. But look at it. Get the CD and put it on 15. 15.
No, 1 second.
Date
15th.
15. Your lordship,
Yes.
21. 21 or 22nd as your lordship.
Take it, 21st, no issues.
21st. Okay. 21st. Okay.
Well, I have an interim prayer also. Not to proceed
Is there any entry mode?
Yes, yes.
Already,
No. This is a trace case.
is there an entry mode?
Well, no, it's a it has come for the first time, my
If
lord.
you notice and Mr. Maharaj entire appearance and we notice and he submits that he would be producing the entire CD
Yes.
before the next date of hearing. Release on.
My lord, may I be part?
Yes.
My lord, item number 58, during the efflux of time, the CR lens become infructuous, my lord.
58 influxes take.
Yes,
more.
I am filing.
As you are seeing time and you said.
My associate didn't know that, my lord. My junior didn't know that.
Now it's.
Yes, I am filing a memo with the liberty to approach this court whenever new cause of action arises.
It's always there.
Yes, that with that liberty.
Recordings. 58, item 58.
58, 58. That liberty may be reflected in the order, ma'am.
Yes.
Oblige.
69 টা আমরা নয় ସବୁ ଗୁଡାକ କହିଲେ time it will take more time from a very relevant question. ଆଜ୍ଞା ଆଜ୍ଞା
ମୋର ଫାର୍ଷ୍ଟ ସବମିଶନ ଥିଲା 2011 କେସ୍ till today we are in 2024.
yes
What is the duty of the prosecution? This honorable court put a question whether the laches lying on the side of the prosecution or the accused.
yes
Prima facie, I have got a good case because I have no way connected because that stone quarry not belonging to me, nothing else. That is from the bare reading of the page 23, it can suffice. For that reason, this honorable court called for a report from the lower court and this one. And another thing, I am submitting before this honorable court. Last order sheet reveals that accused, they were on bail and submitting the PR bond and they were appearing on each and every day. So case has been committed that much.
Yes.
In 2022.
Now, my lord, on 15/9/2011, the present accused was released on bail by the order of this honorable court. 15/9/2011. Plus, you got it. After his release, the other accused persons are there. They also filed subsequently bail after bail, bail after bail. So they also granted bail.
When?
They all are granted bail in 2000 up to 2024. 2012, 11, 2014, 14, all have been granted bail. Now on 13/3/2015, charge sheet was filed.
Yes.
Cognizance was taken on the same day.
Can I submit?
Yes.
Then the date starts 14/8/2015. 14/8/2015 till 2/8/2022. Last you got it? 14/8/2015.
15 to 22.
2/8/2022. All the accused person include the prisoner taking time filing 317 petition or commitment. And on 22/8/2022, all accused being present on the same day, case committed to the Court of Sessions. My lord, lordship got it. Enter date I have mentioned. Enter date. ସବୁ ସିଏ ସବୁବେଳେ absent.
Yes, sir. You tell me.
Both will reply or I'm submitting for that. What is the CRPC? 205/317 is a part and parcel of the.
Where are
I'm submitting before this. Why, my lord, I am submitting? My friend has already been submitted.
Delay is attributed to you or not? That is the question.
No, not
Delay is attributed to the accused person.
No. That is wrong submission. I am submitting.
Proceedings are not wrong.
No, say upper kouchi. 4317. That is. I am submitting because my state council, my brother has submitted before this. The case has been, first thing, case has been initiated at the behest of you. That is the police officer. On 23rd/8/2011.
What is your point? You tell me.
My point, my lord. Prima facie, there is no allegation against me. Second point, there is a delay in disposal of the case. 2 points are involved in this case.
There is delay attributable to you.
No, not against in my favor.
It's all accused.
No. That supposing I am giving an example, not example. That is the case of the CRPC. That is the statute says. I am filing a 317 petition. What is that? Because I was present, my lawyer was present. On which date you have supplied the police paper? Your lordship, I will be directed. This is
that is supplied to you on 13/3/2015.
Nah.
Charge sheet was filed.
Charge sheet has been filed. No police paper has been supplied. I am coming.
Why have you not challenged that cognizance order then? Saying that it was not supplied in cognizance.
How can the clerk concerned supply a copy? They are not physically.
So anyway, but see, now what do you want? You tell me, instead of further wasting time.
11 witnesses, my lord,
11, there are
11.
11 witnesses. How much time will you take?
3 months.
3 months? 3 months.
3 months, right?
Khatam. They are considering. You will be happy.
You will accept it, madam.
3 months.
ସେମାନେ କହିଛନ୍ତି ମୁଁ କହିଦେବି
You want an acquittal from me now?
I know that I will get justice from your lordship.
Just I am giving 3 months. That's the only justice one can give in this kind of situation.
Nice.
Even after someone hear this thing, I am only expediting it, keeping in view that it is a case of 2011.
11.
It is a burden on the system, so therefore it has to be done.
Yes.
Therefore, the petitioner has filed.
Can I submit? One sentence, your lordship may kindly. I have not doctored
Yes,
skill,
tell
but
me.
even though your lordship observing to that extent.
You
My
tell
two
me.
brothers are.
See, I have not reached the 50% of my list.
ନାଇଁ ନାଇଁ ମୁଁ
And I can't waste
ଜାଣିଛି
time.
ମୁଁ ଜାଣିଛି ସେଥିପାଇଁ ବି ମୁଁ ଆଉ ଡିଷ୍ଟର୍ବ କରୁନି ଗୋଟେ ସେକେଣ୍ଡ my two brothers those are appearing on behalf of the prosecution they have undertook to cooperate with the lower court below if they have failed to do so
Then they should be hanged.
ନାଇଁ ଆମେ କଣ କରିବା
What
See, is it expected from you that they are making a fair suggestion to help you out and you want that to bound them?
ଆଜ୍ଞା 14 ବର୍ଷ ପରେ 8 ବର୍ଷରେ ସୁପ୍ରିମକୋର୍ଟ
No, Supreme Court, but you, shall I write all these things and dismiss it? Will you happy? They are trying to help you out and you want to make them bound. The petitioner has filed this petition seeking quashing of the entire proceeding pending against him in GR case number so-and-so, so-and-so, so-and-so. The sole, Mr. Das emphatically argued that though the case is initiated way back in 2011, but the trial is proceeding in a snail space, and his clients are undergoing the rigors of the procedure for more than a decade. Therefore, he seeks indulgence of the court to expedite the trial. Mr. Maharaj, appearing for the state, has elaborately pointed out the manner in which the prosecution has been proceeding, and he submitted that the delay indeed attributable to the accused persons, including the petitioner. Even then, the Mr. Maharaj fairly submits that since the case is pertaining to an FIR laws in 2011 and the trial is unnecessarily prolonging, it would be appropriate that the trial court is directed to complete the trial as expeditiously as possible, subject to the condition that the accused persons cooperate with the trial. Taking into consideration the facts and circumstances of the case and submission at the bar, I direct the court of so-and-so to conclude the trial. Conclude the trial as expeditiously as possible, preferably within 3 months.
One line added, my lord.
Yes.
In ST case number 34
ଏକା କଥା ସେକ୍ସନ ସବୁ ତ ମ୍ୟାଟର ରହିଲେ ଏକା କଥା ଯୋଉ କାହିଁକି
ST case
ST case ଟା ଲେଖିବେ
pending in the file of additional session judge it like
ସେଟା
ହେଲା ସେଠି କୋର୍ଟ ପଳେଇବ
Come.
and from the production of the certificate copy of this order
From the production of certificate.
ଆଉ ଗୋଟେ ସେମାନେ କହିଲେ ସବୁ ଜିନିଷ if that has not been completed liberty is granted to file a better application ସେଇଟା ଥାଉ ସେମାନଙ୍କ କଥା ରହିଲା ମୋ କଥା କିଛି ରହିଲାନି
ଏତିକି କହିଲା ପରେ ସେମାନେ କହିଲେ ବୋଲି ଆପଣ ମିଳିଲା ରିଲିଫ।
ନାଇଁ ମତେ ଭଲ କିନା ମିଳିଥାନ୍ତା ମତେ ଦି ଜଣ ଲାଗିଗଲା ମୁଁ ଜାଣିନି ଦି ଜଣ ରହିଯିବି
ଦି ଜଣ ଲାଗି ଆପଣଙ୍କୁ ରିଲିଫ ଦେଲେନି। So we are in 27. When
Yes, sir.
we
May I implore, sir. The present petition is being accused for commission under section 130 of NI Act Here is, I am challenging the impugn notice annexure 3, page 31, your lordship.
31.
One, yes, your lordship. That NWW issued against the present petitioner on dated 16/9/2023.
NVW,
Yes, your lordship.
how much you will pay?
Your lordship, kindly glance the annexure 22, page 29 and 30, your lordship. A matter has been settled. Out of settlement amount, I have given 6 lakhs as I have given already paid to the informant opposite 2 informant.
Remaining you have not paid NVW.
Yes, your lordship, that's it.
The present case is arising out of a dispute. You are appearing.
My London friend is appearing for the.
How much is
By end of April, your lordship. Balance amount by end of April.
total check amount?
66.
Now
66 lakhs.
Settlement, how much?
20 lakhs the matter has been settled. Out of 20 lakhs, I have given 6 lakhs by a demand draft.
Lego.
And balance amount will be like by end of
Right
April.
down. Dispute, arising out of a complaint under 138 NI Act filed by the opposite party number 2 against the petitioner for having on the allegation that the check issued by the petitioner amounting to 20 lakhs has been dishonored.
No, amounting rupees 50 lakhs the check amount.
50 lakhs has been dishonored. During the pendency of
52, my lord.
That may be
during the pendency of the appeal.
No, my lord, no appeal is pending. No appeal, no.
Trial. Yeah.
No, my lord, if your lordship.
know what is happening. It is the trial stage or
judgment. I have filed the judgment. Annexure 1, the judgment. The London trial court has delivered the judgment and convicted the
You have been convicted. Appeal is pending at that stage.
No, my lord.
Yes.
No. If your lordships kindly see the annexure 3, my lord.
ठीक क्वेश्चन your lordship may kindly see page 26. Page 26.
He is convicted.
My lord, convicted.
Convicted.
And appeal is pending.
No, my lord, no appeal is
He has
pending.
not filed appeal.
My lord,
Judgment
if your
pronounced
lordship-
ହେଇପାରୁନି because of the absence of the accused. Judgment pronounced ହେଇପାରୁନି.
The judgment has been pronounced.
If your lordships kindly see the annexure 3, my lord. Annexure 3, page 33, 31.
No appellate court order filed today.
No.
Appellate order ଆଣିପାରିଲି ନାହିଁ, your lordship. Kindly glance page
No
31.
stay filed by the conviction, no appellate court order filed today.
Huh.
So here no appeal is still filed. If appeal is filed,
My learned friend wrongly interpreted. Your lordship. I have already approached the appellate court, but I have not obtained the appellate court's order.
Stay out.
Yes, your lordship.
if
He
appeal
said that he
is,
has filed appeal.
I have already filed an appeal that
my lord, if there is a appeal, then they give the number,
Why
my
are you
lord.
going into, you have said
ready to
dispute, you
direct
want to
my-
make money. Why are you asking all this?
My lord.
Unnecessarily.
Sorry.
No, लिखो तार ऊपर लिखो the court of SDJ Bhadrak, while its order dated 16/8/2022, record a conviction against the petitioner. Learned counsel for the petitioner submits that he has filed appeal against the order. In the interregnum, the parties have settled the dispute, and the opposite party number 2 has agreed to receive rupees 20 lakhs as a full and final settlement towards the dispute. Out of which the petitioner has already paid about 6 lakhs rupees, and he undertakes to pay the remaining settled amount
by end of
on or before 30th April 2024. Full sum. When the matter stood thus, NBW has been issued against the petitioner, while the impugn order dated
Annexure 3.
Annexure 3. Impugn order dated 16/9/2023.
So kindly interrupt. It is 22 of your lordship. Inevitably that has been
22.
Yes,
22. The petitioner seeks indulgence of this court at this stage for setting aside the said order. In view of the next one, in view of the submission made by the counsel for the petitioner, the operation of execution of impugn order dated 16/9/2022 is kept in abeyance till 30th April. 30th April 2024. I kept it away. Pay the money.
Yes, sir.
Otherwise, it will be
Yes,
My lord, my name may be reflected. That I will file the boklatnama before the register, my lord. So my
file.
Oblige.
Yes.
May I please, lords. The petitioner preferred this serial sequencing of the order dated Annexure 2, page 35,
What happened?
12/1/2024.
What happened by this order?
This order, in the execution proceeding, DW was issued, DW and CNBW was issued.
NBW was issued against you?
Yes. Amount of 5,54,000
What is the 5
for payment of area amount.
Whatever. This is what is this?
Annexure 1, yes, Lordship.
Matrimonial.
DB case, my lord. Annexure 1, the judgment.
Will you pay it?
I am ready to pay. In the order sheet, though I am give my consent to pay, but the learned court below without considering.
Okay, sir. When will you pay?
Yes,
I'll can see
April 30.
Your Lordship, I am ready to pay some amount, not entire amount, because
April 30 you make good the payment.
Yes.
some
5 lakhs,
installment.
54,000.
How much?
5 lakhs, 54,000.
kindly see the judgment, my lord. There is 25 installment. I am ready to pay the installment as per the direction of this honorable.
Comply the order. I am saying it.
Kindly see page 32, my lord.
Where is the order?
Kindly see the page 32. The
30?
order passed in the domestic violence proceeding, page 32.
Operating part?
Operating part in 33 page. Continue, my lord. Continue, page 32. The operating order.
Yes.
The respondent directed to provide 8,000 per month. Subsequently, last two line, the area amount maintenance, that is 5,36,000, calculated from the date of filing of the application, that is
25 equal.
25 equal installment. Next.
Okay, by the order dated, what is the order dated? What is this order dated? Order dated
12/1/2024.
12/1/2022. The court
24.
of it starts from which page?
The judgment of 11/4/2023.
11/4/2023.
This is judgment.
ठीक है. Your Lordship is right.
Why you are intervening? I understood the way you are.
Sorry,
11/4/2023. The court of additional civil judge
JMFC,
Jharsuguda, directed the petitioner to pay the arrear amount of 5 lakhs. How much? 5 lakh?
36,000.
5 lakhs 36,000 by to the aggrieved person, namely opposite party number 2, with the by 25 equal installment. Full sum. The petitioner appears to have failed in complying the said order. Therefore, by way of impugn order, NBW has been issued. The Learned Counsel, next one. Learned Counsel for the petitioner submits that he would be he undertakes to comply the order within undertakes to comply the same order and surrender before the submit to the jurisdiction of the court on or before 20th of April. Taking into consideration the aforementioned circumstances and submission made at the bar, the order dated 11/4/2009. NBW order
12/1/2024.
12/1/2024 is set aside. And the petitioner is directed to appear before the court and make appropriate prayer before that court.
See, order title ଭଲ ହେଇଥାନ୍ତା.
Court.
He kept in advance till
Like 25 installment. If I will give April, all the 25 installment he has to pay within April. Where come he get it? Let him go. I'm setting his head. Appear and seek the prayer. You go and appear there. I'm set aside. Okay, go ahead.
Oblige.
25 installment. Who will calculate here? Let him go and the court will give. Go with some money and pay. And,
I am ready to pay some amount.
Whatever money you go and pay.
Date I fixed to tomorrow, but I will.
I have set aside where it will go tomorrow. Go. Yes.
Oblige.
29. Yes.
May I please, ma'am? The present petitioner is a sub-inspector of police, and because of some dispute, intercity dispute, the IAC of the same police station has lost the affair
against the petitioner and the husband, and the parent petitioner also lodged a FIR against the other side. And the Supreme Court, taking into account all such aspects, had kind enough to give stay and also issue notice to the opposite party.
Opposite party, who is appealing?
We are not filed.
You have not filed.
There is notice to the command by registered court of registered court. AD along with the address statements, not filed.
Address in course of the day I'll file. In course of the day.
This interim direction was passed on January 20.
Again.
And you have not filed requisite. That is the danger giving a stay.
But sometimes
I have been telling.
what has happened.
Every day I am telling.
No,
That is the reason the 482 courts
my
are
lord,
loath in giving.
No, my lord may not misunderstood on a particular aspect. Yes, I do consider this a
How much cost will you pay?
1,000.
1,000. By way of order dated 13/1/2023, notice to the opposite party was issued by the coordinate bench, and an interim direction of staying the further proceeding was also passed. However, the petitioner has not filed the required requisites, as a result of which the notice on the opposite party number 2 could not be served. Mr. Manas Chand, counsel for the petitioner, seeks one more opportunity to file the requisite within
tomorrow.
By
my lord is also peremptory.
By tomorrow, subject to the same prayer is allowed, subject to the petitioner depositing paying cost of rupees 1,000 to the welfare fund of the High Court.
High Court Bar Association.
Leaves the matter on 29th.
Interim order continue.
Interim order to continue. Yes.
30. My lord, I pray for next week, my lord. The matter has been compromised, my lord. I have already informed the informant, my lord. Let it come there.
A notice has not been.
Notice, my lord, that I have.
Matrimonial.
No, my lord, portfolio, my lord. Already compromised, my lord.
What is the offense? 420.
My lord.
Okay, 420.
Yes, my lord.
Issue notice. Issue notice.
Notice are already issued, my lord.
Yes, notice.
My lord, already informed, my lord. Next week, my lord, I'll.
Where is he?
Bharti Roy, hey, my lord, I have already informed, my lord. Informed, my lord.
Where is he? Either he has to come or he's.
No, next week, my lord. Next week, I pray.
You want an adjournment?
Next week, my lord.
Bring him, huh? Next time, yes. Yes. Next.
31. May I please your lordship?
This is the extension of the order dated 2nd January 2024.
Extension.
Lordship.
What is this order?
Order was to surrender before the court at Jajpur, JMFC Jajpur, STJM Jajpur. STJM Jajpur. But unfortunately, 13th, 14th, and 15th were holiday, and that is why I couldn't appear by surrender.
When are you going to appear?
15 days.
Days. In the last order, I have not said when to appear. Whenever you appear. What is the extension?
No.
Where have you said? Once he surrendered in the same manner, he been dead.
The petitioner is directed to surrender before the trial court within 15 days from today.
Where is that?
Last page of the order.
Within 15 days.
Within 15 days.
The order dated 2/1/2024, the petitioner was directed to surrender within 15 days. And seek remedy available to him under law. Due to the difficulty as explained in the application. The application drawn up. Flag na application. Which is the application?
147 of 2024.
Flag na 147 na.
Let's see.
Application. He could not surrender and seeks further time. Taking into consideration the submission made by the counsel at the bar and considering the contents of the application, further 15 days time is granted to the petitioner to surrender before the trial court and avail the remedy under law. And it made clear that no further extension shall be granted. Yes.
32, my lord, here I pray only for 2-3 days time for appearance of the party as it has been settled between the parties, but I have to keep it to fifth.
Direct to the opposite party to appear in the PS manner, police station. Notice of them, they did not appear.
No, my lord. In such a case, my lord, my specific contents of my lord taker, they went to the police station says that because of the pendants of the case and because of no direction is there.
No. The Mr. Raghuda directed to produce the notice to opposite party shall be issued by now requisite everything is filed. Filed.
Paragraph 4, my lord, dated 5/1/2024.
That's what I'm reading.
The IOT case shall appear before this court through virtual court on the next date of hearing and shall make necessary arrangement for appearance of the occupied 2 and 3 matter.
Where is it?
Did not matter appear
It was not, my lord, may see the specific date was there. They are the date, my lord, they went to the police station and because of the fact that they.
No, for today they should appear.
Last, my lord says it was before 2 days before. It was 2 days before.
No, next date of hearing.
Again.
Means today they should have been they should have gone to the
prior occasion. The date, my lord.
contacted IO today morning, my lord.
They have not come.
My lord, may take it on 5th, my lord. Monday. Till. No, Brahmpur was here.
They will not appear.
No.
And notice also solved, my lord.
No, where is your IO? Show me. Where is your IO?
I have given the link and also presented the police station.
Where is he? Call him, let him come. They are the party, but he is an officer. He has to comply the court's order. We can't be lenient insofar as the officers are concerned. They are the party, they have settled the dispute, whatever. I am passing it over, just see, check it up. Next.
May I pray?
Let him come. Whenever he will come, let us see. See, the client may be giving some instruction to you, they are doing something there.
No, Nabrangpur, because of the fact that they are staying in a remote part of the village, they went to the police station on a particular date. On the relevant date, it was not listed. That is the reason things has come up.
There may be some confusion. Let us understand and let us see. In the ground, who is handling? The IO is handling. He may be facing some problem. The client might be giving some instruction to you, some instruction to me. Let us understand from him. We'll adjust in that.
ଆମେ କହିଦେଇଛୁ ଆଉ ଗୋଟେ ଡେଟ୍ କରନ୍ତୁ ସେ ଦି ଜଣ ଯାକ ସେଠିକି ଯାଆନ୍ତୁ ଆମେ
କେବେ ଫୋନ ଅଛି ଡେଟ୍ ଫୋନ
Monday
fifth कर दो
Monday आगे
simply fifth कर देना
माइल simply fifth
आप लोग कम्युनिकेट कर दियंतु
କମ୍ୟୁନିକେଟ ଅଲରେଡି ହେଇଯାଇଛି
there may be some communication gap
ସେମାନେ ଯେହେତୁ ଆସିନାହାନ୍ତି କୋଅପରେଟ କରିନାହାନ୍ତି ତେଣୁ ଆସନ୍ତୁ କରିଦବା
link ରହୁନି. So what is the exact problem, my lord? In the police station, the link is not properly working. My lord, may just twist this particular order to only to the extent the IO will take the party will appear before the concerned IO. IO will bring my lord produce them before the concerned BC of Nabrangpur.
In mobile also anybody can
link आसुनी है सब फेलोस link सब वेले फेलो रहेगा सेट पे Nabrangpur court मतलब virtual court is there. They will the IO will brought them to Nabrangpur court देनी चाहिए.
All these things judicial order why should you express you just simply tell कि भाई you go take them to court and then from there unnecessary
verbal
why unnecessary judicial दरकार नहीं गुड़ा 33 ଆପଣ ଖାଲି କହିଦେବେ कि भाई ଯଦି लिंक मिलुनी कोर्ट को नहीं जाओ सेठी कराई दे काम खत्म हां नो प्रॉब्लम
मैं प्लीज योर लॉर्डशिप in the last occasion as per your lordship's direction I have given the requisite method but in the cost list it hasn't mentioned that complete requisite has not been filed for that reason notice could not be issued so I will bring that I will file a fresh requisite my lord
requisite file जी हाँ तो कौन होगा
yes location postal positive page we are
incomplete
yes my lord
requisites
exactly I don't know what is
take further steps
yes lord
take further steps okay Mark the period. Next.
Your Lordship, may I pardon that? A date may be fixed, my lord.
He's giving the date.
Oh, please.
34, may I please before your lordship. On behalf of Mr. Sarup Patnaik, may I permitted to place this matter. My lord, here in this case, my lord, the police submitted the final report at page 46. That is the mistake of fact. Lordship, running page 46. 46, 45 and 46. The fact of the case, the police has submitted the final form, last operating part.
Who are you?
I am the accused in that case, my lord. After, my lord, final form, my lord, 1cc case has been filed in shape of protest petition. I have also filed a 205 that has been rejected, and it has annexed that order, my lord, at running page 111, my lord.
What is your grievance?
My lord, I am
205.
My lord, at 205 to quashing the entire proceeding on the ground that the civil case is pending on the self-same allegation by the complainant, and that is not as per the final report, my lord. I have also annexed that document annexed to running page 51 of the civil suit, my lord. Thereafter, my lord, suppressing that fact, my lord, they have filed a protest petition, and I have appeared in the complaint case and filed a 205 petition, and the same has been rejected at page 111 also. On the ground that, my lord, lordship have a glance, my lord, in the charge sheet, my lord, page 45, my lord.
What is the allegation?
Allegation 420, the land has been sold to some other persons. ROR recorded in their name, second subsequent persons. Civil suit pending, civil suit filed by the complainant against that man also. And that status quo order has obtained. And complaint case against the present petitioner along with some other person.
You have sold. You have sold the property.
I am sold
to the informant.
To the informant earlier, first sale. Thereafter, my lord, and thereafter
again you sold the same property to someone else.
To someone else. ROR has been thereafter. 3 writ application has also been
filed. He has filed what? He has filed specific performance.
My lord, I have annexed that, my lord.
Says, tell me, annexed. Forget about it.
Cancellation of sale deed, my lord. Your lordship.
Subsequent sale deed.
My lord, and at page, my lord, 61, my lord, the relief sought for.
Okay.
My lord, thereafter, my lord, protest petition filed in mistake of fact. In the I am relying the decision, my lord. I have quoted in running page 11, my lord, of my petition in view of the 2017 2 OLR 643 in case of Venudhar Sahu and others. This honorable court observed that a dispute being purely civil in nature, no criminal intent can be displayed by not.
But both the things can also go together. That is not an issue. Issue is, let us see what are the allegations against you. It is 468, 471. Have you forged the document?
No, my lord. Second subsequent seller alleging as per their complaint petition. And civil suit is pending. I am appearing.
You sold it to the informant by sale deed or agreement to sell?
No. There is some sale deeds are reflected, my lord.
That is what the fact you have to tell.
Fact, my lord, civil suit out pura देखिए पड़ो तादर 144 and CRLMC.
You have to tell me the fact. You can you say that I don't know the fact, but you
no, I am placing that, my lord, portion, my lord, in the police has been ascertained in page 45. I am placing that operating part, my lord. The complainant Sri Krishnal Agrawal, son of managing director of Ma Chachika Cold Store Private registered company having its registered plot number 791 Gandhi Chowk, Noya Bazar, Chauliaganj, submitted a written report at Barang PS to the effect that he has purchased the plot at Madhuban Mauja under Barang police station by 3 separate sale deeds bearing number 3860 dated 16/10/2000, 4241 of 16/10/2000, 755 dated in the year 2001 from the rightful owner, namely Durga Pradhan, wife of
this is coming for first time. We simply issue notice, let us issue notice to the opposite party number 2. OP2. Returnable within 2 weeks.
Stay up further proceeding, your lord. My lord, there is 205 is there.
You yourself is not clear about the facts. and you want to.
My lord, 3-4% have been sold thereafter, my lord. In
That is the reason. That is the
I am
reason.
placing that
The
operating.
land has changed hands, and you are instrumental in it. That she read the charge sheet.
I am placing that charge sheet, my
Charge sheet,
lord.
I read it.
My lord.
I read in the charge sheet, so no question of stay. I will just see if any thing can be worked out.
My lord, otherwise, the
You
lower court-
move. Nothing is. What is the stage of trial?
The trial, no, I am appearing 205, my lord. Your lordship have a glance in page 10.
And then counsel for the petitioner submits that his application, IMA, his application under 205 CRPC has also been rejected. In this petition, he is assailing the said order as well.
My lord.
As well. What is the stage of trial?
No, my lord, they are not, I am a page 112, my lord.
You have to appear.
My lord, if I will not bail
What
out.
about, then you have to get the bail as
Yes, my lord, they will, I am 205, I am allow kar denu, we will come appear before the contest the matter.
the letter counsel for the petitioner submits that he would surrender before the court and seek appropriate remedy available to him under law, and therefore he is under law. Accordingly, the petitioner is at liberty. Petitioner is directed to surrender before the court on or before 20th of February 2024 and seek appropriate remedy available to him under law.
My lord, if you will not allow my petition, my lord, 205. My lord, not opposite party took notice, how say
Simple notice.
Huh?
Simple notice to charge.
Returnable within, my lord.
Returnable 2 weeks. Nothing. Only notice to opposite party. Requisites filed. They will see. Yes.
Otherwise, the trial court will proceed, my lord. I will be facing trial.
I am giving you opportunity. This is not a bail court. I can't grant you bail.
No,
Is it a bail court?
No, my lord.
So you have to go to the bail court. That's what I'm saying. Surrender and take the bail.
Surrender 420 case rakhi doujhanti, my lordship. That is the
ତାହେଲେ
problem.
ରଖିଥିବି surrender ରଖିବନି ଲେଖିକି ତଳେ.
No, on surrendering will.
Try to at your exposure you have to assist the court appropriately when I can pass the order.
Further proceedings stay no coercive action
No coercive action now. No coercive action. Then you will file requisite and then no, nothing doing. I am giving a short that you come and we will see. Next.
35.
35.
Petitioner is the husband, my lord, filing this petition for quashing of the petitioner is the husband, my lord, filing this petition for quashing of the city case number. My lord, marriage has already put an end, my lord. Already permanent alimony has given, my lord.
Mutual divorce
My
has
lord.
taken place.
My lord. Annexure 3, my lord. Annexure 3, page 39, my lord.
Has she said that she doesn't want to proceed with you?
My lord.
Has she said in the settlement that I will?
Well, notice has to go to the wife. He has.
That I know. In the settlement, has she said that I will not prosecute this case? She has not said.
No, sorry. She has to appear and file an affidavit here.
Petitioner is seeking indulgence of this court for quashing up for the entire proceeding in city case number SS so and so. Page he submits that the petitioner, counsel for the petitioner submits that the petitioner was the husband of the opposite party number 2. They have settled their dispute. Pursuant thereof, they moved application under section 13B, 13B of HMA Act, and obtained which order?
Well, not 13B, but it was filed on 13(1)(1)IA clause 1IB.
Divorce you.
Divorce petition was put an end. And accordingly, divorce was granted and permanent alimony was paid by to the wife.
Okay.
Person thereof, they moved on a.
You have settled the dispute. They have settled the dispute. Person thereof, they have got the decree. He has got the decree of divorce and paid the permanent alimony. Permanent alimony. Next paragraph. Issue notice to opposite party number 2. Next paragraph. IRA and in the internagnum, the proceeding before the court below, so and so is stayed till next date appeal. Huh? Till next date appeal, 20th.
Well,
I have stayed the proceeding
well,
and you file the requisite. 20th is the date. Bring
Only notice go to
opposite party number two.
Other opposite party are there, my lord.
opposite party number 2 only.
Two old.
Yes.
36.
District man.
Adjourn.
37.
May I please, Your Lordship? I challenge the order of a cognizance taking 29/6/2023 additional district judge cum special court, which is not attracted as per the date birth of a victim. Your Lordship may kindly, during the investigation of a police in final report, the police present that the age of victim girl is minor. But Your Lordship may kindly see the Annex 3. As per the Annex 3, the age of victim girl is 18 years, 2 months, 5 days.
Date of birth is 10/8/2004.
Yes, Your Lordship.
So then what happened?
My prayer is to question the order of cognizance taking
Why? Because 18 then
under
376.
POCSO Act.
Huh?
POCSO Act. Your Lordship.
POCSO is not included. Is it POCSO? Oh, sex. You are over enthusiastic coming to the court.
I let the cost maybe explain.
Hey, cost will be there. The cost you are paying to your brothers only.
My lord.
What problem we are facing because my leader is here.
And he is instrumental in.
We are not able to get seminars.
Now,
Since now long years,
we are,
our bar is also not a conveying seminar to educate young lawyers.
We are collecting this for this purpose only.
We are very intended to hear my lords in a seminar.
Thank you. Thank you. Yes.
42.
I mild it. Okay. I'll not write much.
Mild.
I mild it. Only.
Oblast mild.
But
Oblast.
1000 will be there. Okay.
Oblast. Oblast.
Because his government servant unnecessarily prejudicing by another.
Oblast.
Yes.
May please your lordship. Lordship kindly see order dated 5th January 2024 and last occasion your lordship was pleased to
January. Okay. Is notice to the opposite party.
Directed me.
Party number 3. Where is opposite party number 3?
My lord, opposite party number 3 in the meantime died, my lord. Died, my lord. Expired, my lord.
Are you unable to, my lord, get the same, my lord? Because the opposite party expired in the meantime.
Meantime. My friend is appearing for the opposite party number 2.
Expired not because of the injury, na?
No, my lord.
You are accused of
no, my lord. Just occurrence occurred.
2002
perhaps last year. I got information yesterday. Perhaps last year he died, my lord.
He might have died, no problem. Are you sure that the death is not because of you?
No, my lord. No.
Therefore, the petitioner has filed the present petition seeking quashing of the what is this order? Cognizance.
My lord.
Settle pay. I have not कहला. I
have quashing of order dated 21/8/2003 passed by the JMFC in connection to the case in page 82, whereby the cognizance of offence under section, where is that order?
My lord.
Under section.
Kindly see order dated page 15, my lord.
Yes, page 15. देखो section order नहीं जो IPC against the petitioners. Full stop. The petitioner, petitioner submits, the counsel for the petitioner submits that they have settled that dispute. On 5/1/2024, this court had issued notice to the opposite party number 2, who is informant, and opposite party number 3 was impleaded, who was the victim in this case. The victim in this case. It is informed, Mr. Ragada appears for the petitioner, appears for the state and submits that he has got the instruction from the IIC of the concerned police station.
Madam, the notice over notice answer, madam. IIC were not able to trace out.
Death hai na?
Death notice ta approximate notice.
Notice already sought.
Submits that he he got the instruction that opposite party number 3, who is the victim in this case, has already expired. Full stop. Next paragraph. The opposite party number 2, Sukandi Purada, na? Opposite party number 2.
Informant, my lord.
Opposite party number 2, who is the informant in this case, has filed an affidavit before this court, inter alia stating that under the intervention of the local gentries and well-wisher, they have settled the dispute, and she doesn't want to proceed with the matter against the petitioner. The opposite party number 2 is represented by her counsel, Mr. Sunil Kumar Panda, and Sunil Kumar Panda. She has identified the signature appearing in the affidavit. Have you filed Aadhaar card and all?
Yes, Aadhaar card no.
Just now.
The parties have filed their self-attested copy of Aadhaar card to build up with their identity.
Aadhaar card will file.
Aadhaar card admin
will file, my lord.
sign kala kon
In course of the day will file.
Kali se complaint karibo je
Tomorrow, my lord. Tomorrow they will come.
Please Aadhaar card.
Yes, my lord.
Otherwise you people will interrupt.
I don't have any. They will come, my lord.
Tomorrow somebody will come and see. I am
No. They will come, my lord. They will come.
Unnecessary way. Tomorrow, huh?
My lord, obliged.
Yes.
May I please your lords?
Order that how, huh? He order that house. Actually, can baki jodi do.
My lord.
Yes.
Item 43. May I please your lords? In the present case, arising out of matrimonial dispute, but on the face of reading of the FIR, your lordship will find the abusal of process of law and the investigation report. Only 2 things I will place. I am confident my lord will be convinced.
Who are you? Mother-in-law, father-in-law?
We are all the family members of the in-law.
Except husband.
No, husband is also there, my lord. Everybody has been entangled.
Who is husband?
3.
Sanjit.
My lord, 3 is the husband.
Sanjit.
What
is the allegation?
My lord will find the FIR. The relevant person I have just placed. She is a police personnel working in the same area. Working in the same wife.
Okay.
Therefore,
is a constable.
Madam. And the background of the case.
Husband is also a police.
No, I am a vocational teacher. From the day of marriage, I have been underestimated. That was the cause arisen. The dispute and some affairs are there with the wife, which has been got red-handed by my brother, which has been, he has taken photograph of the situation. Therefore, this case, I will just indicate whatever there in record. Now, you kindly have a glance. She is residing in police colony. Second line of the page 9. Page 9. Page 9.
Yes, read it.
Rasmita Lenka, so and so. Quarter number so and so, police colony. The entire page is more marriage related, whatever. We have paid such and such. No allegation regarding dowry or torture. Your lordship come to the next page. Relevant portion I will read.
Yes.
The entire thing is that now your lordship will find page 10. Third line. Because they said will kill you, that is the allegation.
You read the reason you are not reading the allegation.
I'm not feeling comfortable because some.
It's all right, skip those words.
Yes.
It is a complaint case, 153.
Yes, my lord. Arising out of complaint case.
And,
The complaint
153,
my lord.
Where is the charge sheet?
Charge sheet has been filed. I have not obtained the charge sheet.
Then
because of the 1cc case has been arising, absolutely there is no allegation against the present petitioner.
Get the
And
charge
then
sheet.
the complaint case, one Subhash Chandra Naik is the accused person.
Whatever, charge sheet after investigation, charge sheet is filed now. Let us see the charge sheet.
One week after it will be
Let it, without charge sheet, how can I
call
quash
for
it?
the CD? Better your lordship.
No, it is your petition, you have to satisfy me first. Thereafter CD.
Call for the
You
CD.
file whatever you want, and the entire court and prosecution, everybody will be with you to get your annexation.
As your lordship, I have nothing.
It is your petition, you have to satisfy prima facie you have a case or not. If you want quashing of a petition proceeding, the minimum thing is the charge sheet, which is not there on record. Yes.
Your lordship, fix a date.
Date will be fixed. Whatever date possible, we will give it. Yes.
May I please, Your Lordship? But this case arises out of a complaint petition. My lord, where the learned magistrate took cognizance under sections 420 with other offences.
Yes.
Your lordship will kindly turn to page 9.
9,
Yes, ma'am.
Yes.
Cognizance was taken after perusing the complaint petition and after taking, my lord, recording the statement, initial statement and 202 inquiry, my lord. The learned magistrate was pleased to take cognizance under section 420, 452, 506, 34 of the non-penal code, which is a warrant procedure case, your lordship knows, my lord, because it is more than 2 years, my lord. It is a warrant procedure case, my lord. Now, the learned magistrate, after taking cognizance, directed for issuance of summons, my lord.
Yes.
I filed the requisites.
You filed?
I filed the requisites in the address as revealed in the complaint petition, my lord, where they were staying, my lord. I filed the.
You are the complainant.
I am the complainant.
Okay.
My lord, I filed the requisites, my lord. But unfortunately, those my lord, summons issued to the accused persons, they returned back with a noting that they are no more staying in that address, my lord. So I was directed to, my lord, take fresh step with correct address. I could not collect the correct address for a long period. I took time.
Do you have now correct address?
I have now correct address. My lord, thereafter, as per the order of the CJM, the learned magistrate dismissed the case exercising power under section 2044, my lord, which is, of course, my lord, in my considered view, my lord, it is not applicable to the warrant procedure case.
Where is the impugn order? Impugn order is?
No, my lord, it has been dismissed. Thereafter, I filed, after getting the correct address, I filed application under for restoration of the case, Annexure 2, my lord, my application. That has been rejected now by the learned magistrate under Annexure 3, page 40.
What does it say?
My lord, he says, my lord, that on perusal of the above order, it appears that the complaint petition of the present complaint was dismissed on the ground of his non-furnishing of correct present address of the accused since long, as per section 2044 of the CRPC. Thereafter, he.
What is the allegation?
Allegations are very
Are you
serious.
sure? Are you sure that you want to prosecute them still?
Yes, madam.
2016.
Otherwise, I would not have filed the application, madam, for restoration. If I would.
I'll issue notice if you can successfully serve them here, and both of you will send there.
Your lordship knows, my lord, it is dismissed before summons were served.
That's right. In this petition, I'll issue notice. You serve them. Let us see you are successful or not. If you are not successful, then sending it back is useless.
No, but what I
in any case, you are not able to serve.
In a warrant procedure case, if at all, my lord, I fail to give the correct address, my lord, the learned magistrate has got a power to exercise 87 and issue a warrant against the accused persons.
If the accused person they are not in existence, it is
No, no,
It is-
they are in existence. ସେମାନେ ଆଉ ଗୋଟେ ଜାଗାରେ shift କରିକି ଯାଇ ରହିଛନ୍ତି ଯୋଉଟା କି ମାନେ ସେ ଲୁଚିକି ରହିଛନ୍ତି ବର୍ତ୍ତମାନ ସବୁ. Because they know that I have instituted a case, my lord. They left that place and they went away, stayed somewhere else, my lord. They are moving
Well, in any
from
case,
one place
in
to
any case,
another.
insofar as this petition is concerned, we have to issue notice. If they don't come, then we will.
ଦରକାର ନାହିଁ ହଜୁର ମୋର
what,
because there is a
Mr. Maharaj?
decision of Kerala.
Copy ନାହିଁ,
Kerala
notice
High
ଯିବ
Court.
କାହିଁକି it's a complaint case. Notice is
No,
mandatory.
no,
Unless
complaint
until
is a very peculiar situation.
Yes, yes.
Situation is his complaint, cognizance was taken. He filed the process. A process somehow it was not served, and he did not give the fresh address. If he did not give the fresh address and it service is not affected for any reason, under the warrant trial, the stringent process should have been available. Thereafter, NBW should have been issued. How can you come dismiss the complaint?
Yes, no.
Merely because
I fail to.
and suppose he will say that, no, I'll not. Suppose he would not have given.
Supposing, my lord, he moves around, changes his place of.
And you keep on giving.
Even I take notice now, my lord. Supposing in the meantime they will shift to some other place, my lord. Again, I will be unsuccessful. So the magistrate has got the power to issue a warrant against them, my lord, for the purpose of securing their attendance to proceed with the case, my lord.
Right.
That he has not done.
The procedure has to be followed.
Requisites file. Requisites file.
Everything filed. He moved an application for restoration. He dismissed. He moved an application for restoration. That is also dismissed. Okay, right now. The petitioner is assailing the order dated 22/11/2023, passed by learned GN. What is that? GN come JMFC.
Gramya Nyayalaya.
Gramya
Nyayalaya. Gramya Nyayalaya.
JMFC.
In what is this number? In
1cc number 11 of
1cc number
11/27.
Yes.
2014-19.
2014-19, whereby the petitioner's application for restoring the complaint case has been turned down. Full stop. Mr. Mishra, appearing for the petitioner, submits that the court below, by the order dated 9/8/2016, had taken cognizance of offence punishable under section 420/454/506/34 IPC against the accused persons, namely the opposite parties. Opposite parties. Full stop. However, therefore, the opposite party. Therefore, the court below should have followed the procedure contemplated in CRPC in a warrant case by issuing appropriate appropriate process. Instead of following the said process, the trial court dismissed the complaint case filed by the petitioner.
Yes,
Therefore, he had moved an application after getting the fresh addresses of the accused persons. Even after furnishing the fresh addresses of the accused persons, the trial court turned down the application.
Along with the application for registration, which has been turned down.
Along with the application of restoration, which has been turned down. Therefore, the petitioner seeks indulgence of this court. Since the trial court had taken cognizance of offence punishable under section 420, 452, 506 and 34 IPC against the accused persons oblique opposite parties under the procedure contemplated in the under the criminal procedure code, the service of summons and service of the process on the accused persons is has not been done as per law.
Therefore, I am of the considered view that the order dated 22nd, 22/11/2022 is not sustainable under law. As such, the same is set aside, and the complaint case is restored to its file, and the trial court is directed to follow
Proceed with
the
the-
procedure of the issuance of
As contemplated
process
in a
Process.
process to the accused and proceed with the case.
As contemplated in
As
a
contemplated
warrant case.
in
Warrant.
the warrant
Warrant.
and proceed. ठीक.
46.
Yes.
Under this case, the petitioner seeks to challenge an order passed by Learned SDGM Kamakhya Nagar, whereunder the Learned Magistrate was pleased to reject the prayer of the petitioner under section 205 of CRPC, who had prayed for dispensing his personal attendance.
What is the offense?
My lord, your lordship, offences are triable by Learned Magistrate, for which cognizance was taken. Your
Where is this case is going on?
Kamakhya Nagar SDGM.
Where are you staying?
My lord, beg your pardon.
You are staying at
My lord,
Dhenkanal.
Dhenkanal. My
How
lord,
far it is?
my lord, it's 40 kilometers. That my grounds of submissions, your lordship may kindly see. Annex of 4 series may kindly see, the page from 34 onwards. The petitioner, my lord, happens to be an APP, Assistant Public Prosecutor, attached to Dhenkanal Court, my lord. At
Good.
page 35.
Good that you are a lawyer, you can go to another court.
My lord, what I beg to submit, I have to discharge duties of the court, my lord. My lord, can I go away, flee away from the course of justice?
Right.
ଏଭଳିଆ ଲୋକଗୁଡାଙ୍କୁ 205 ଟା ଦବା ପାଇଁ, my lord, Lord's court has become reluctant. I fairly submit, my lord, that can he go away? He is a law-abiding man. He is now working in
APR and BC, nowadays BC facilities are there.
First appearance by right. First appearance by right.
Appearance is
My lord, unless the first appearance is dispensed with throughout the proceeding, my lord, as and when required, he will appear. Not that it is not a case depends on identity.
Are you on bail or not?
My lord, bail has, if bail has been granted, my lord,
That is the underlying thing.
bail, summons we have come.
You want to face the trial in absentia without bail?
Yes.
Because you are a public
Assistant
prosecutor.
Prosecutor attached
So
to
therefore you want to face the trial without appearing in the court, without taking bail. That is what the case is.
Yes, your lord. So but I undertake that I will.
And he says how fairly
My
he
lord,
says.
I undertake that I will appear before the trial court as and when court will be pleased to direct me.
And now the court has already directed you go now, appear.
My lord, this is the initial step.
You get the bail first, then I will help you in the sense that I'll say that you will appear through VC, and as and when physical appearance is required, you will appear.
My lord, for that 307.
Why have you not? What is the offense?
Offense, your lordship, you are tribal by law and magistrate.
So why are you scared? You will get the bail.
What has happened, my lord? This petitioner belongs to a village.
Whatever, I am not on that. The only serious offense is 354B.
143, 452.
307 is also there.
My lord, your lordship, page 33. Page 33, cognizance order is there.
Okay.
Those offences have been eliminated from the.
What is the allegation?
Page 33, 143, 452, 294.
All these things you get the bail on 323 and all. What is it?
My lord, what I beg to submit, this is a counter case. And original case.
Are you challenging 205 application or
only?
Other than why are you going to merit unnecessary? You appear in the first day, thereafter on VC.
And it is also mentioned, he can also take recourse to section 317 of CRPC after his appearance in the court whenever necessary.
Why unnecessary challenging? You go, why are you so making a ego issue out of it? Court has given you everything.
While rejecting the prayer, your lordship,
it appears to be an ego issue. That's all.
No,
I will not go and appear.
My lord,
because I am a lawyer.
No, that is not the reason. He is the my lord. What I beg to submit, I have got instruction that entire villagers have been prosecuted in this case because of a meeting they held in a communal purpose, my lord. this informant and his son were involved in some village affairs for which a meeting was convened. And in that meeting, all villagers have been implicated, all gentlemen have been implicated. And this petitioner who happens to be a lawyer, my lord, he is a member of the village committee. That
Whatever,
instruction I have got.
The petitioner is agreed by an order dated 6/11/2023 passed by SDGM Kamakhya Nagar, whereby his application under section 205 CRPC has been rejected. While rejecting his application, the related SDGM has observed as under last paragraph, page 46. A settled principle of law. In view of the aforementioned observation of the learned trial court, no interference by this court under 482 CRPC is called for. However, the petitioner can pray before the trial court. Interference is required. However, in view of the fact that the petitioner is a practicing lawyer and additional PP,
Assistant public prosecutor.
and an assistant public prosecutor engaged in which court?
ढेंकानाल court.
In ढेंकानाल court.
Executive magistrate as well as judicial magistrate that has to.
ढेंकानाल court. If he is advised so, he can move appropriate application before the court for dispensing his personal appearance and also appearing in the court through video conferencing mode. Disposal. Move application for
May be indicated after his first appearance. These recourse of law.
first appearance. He will take the bail, and he undertakes. When will you appear? Tell me. I'll record your statement.
In the next date fixed by not. I do not know what is the date.
For the petitioner also
Within a month, you will also
and makes it it submits that he would be his client would be appearing in the next date appearing in person and avail remedy the remedy under law. Appear next date and thereafter move application for.
My lord, that have indicated so that.
I have indicated. Yes.
47.
May you please, Lord.
This indulgence is because he is a lawyer. Otherwise, there is nothing. Yes.
My lord, the application has been filed for necessary direction for early disposal of the case. The occurrence is in the year 2013 and the charge sheet has been submitted in 2014. And after 8 years of submission of charge sheet, the trial was started and PW1 was examined on 17/9/2021. And lastly, the PW8, who was the informant, was examined on 17/12/2022. And after that, the cross-examination was deferred and the case was adjourned. And after that, he was not coming to the court and deliberately is delaying the trial.
Every time you are enjoying, you are moving application on 317.
My lord, 300, whatever to submit, I am concerned in the case. My lord, that is not the reason. What has happened, your lordship? Here
the proceeding just
witnesses have been examined accepting this complainant. My lord, complainant is a lawyer of ढेंकानाल court. He appeared once. Cross-examination was deferred. Thereafter, he is not turning up.
Is this a connected case?
Yes, sir.
The one which you argued?
No. This is another case. My learned sister is one. Here, my lord, accused persons are running to the court since from the date of framing of charge.
Not running to the court.
Accepting
moving application under 317 every time.
But 317 because 317 that recourse of law can be taken.
Can be taken, but you are also not interested.
No, my lord. In absence of accused persons, the trial is going on. There is no question of there is no direction was given by the law and court.
How many witnesses are there?
10 witnesses. Out of 10, your
copy ଦେଲେ ତ ସେ ଜାଣିବେ।
ଚାର୍ଜ ସିଟ୍ କିଛି ନାହିଁ, ଚାର୍ଜ ସିଟ୍ ର କିଛି କପି ବି ନାହିଁ।
ଚାର୍ଜ ସିଟ୍
କେମିତି କେତେ ଜଣ ସାକ୍ଷୀ
ଟୋଟାଲ ଅଛନ୍ତି? How will you know?
ଚାର୍ଜ ସିଟ୍ କପି ଦେଲେ ଜାଣି ହେଇଯିବ ନା କେତେ ଜଣ ସାକ୍ଷୀ ଅଛନ୍ତି।
But I have the charge sheet, but there is 10 witnesses, sir.
How do you know?
ଆପଣ କହିଲେ କେମିତି ହବ? ଅଛି ଯଦି ସେଠି ଦେଇଦିଅନ୍ତୁ।
You should, I will charge it to know.
Forward a copy to my lord.
There the copy.
By tomorrow. Let it
Come, let it be,
listed on next week.
not next week.
I will give it.
See, we are approaching 4 o'clock. I am in item 48. You got an opportunity, you wasted time. Likewise, if I keep on adjourning matter next week, how will I adjust?
My lord, I have got the copy. I will just now.
Keep it with you. Whenever you feel like you file it, and matter will be taken up on that day. Give it a day when it's possible. This is minimum thing.
My lord, I will pass on the copy to my lord.
No. He has to verify it. Who knows? One paper is missing there. High Court proceedings shall not be taken so casually. One page petition, 2-page petition, bus. Without any material, without anything, file and ask for relief. How can it be done?
My lord, there are 10 witnesses.
You are a youngster, you should not be allowed to do that. It should be an exhaustive petition. You should indicate how many witnesses are there, how many are examined, when examined, everything. You are asking for indulgence of the court for speedy disposal of the trial, you should give every particular. Next item. 48.
May I please, Your Lord?
Yes.
Your my lord, the petitioner is the husband of the informant, wherein my lord, I filed the application for quashing of the entire proceeding on the FIR, my lord. Your lordship, kindly see annexure 1, page 11.
Yeah.
Second para, my lord, the marriage, my lord, in the year 2015. She remains silent. Thereafter filed a petition for under Hindu Marriage Act for divorce, my lord. In second para, it is mentioned, my lord.
Who filed?
The wife filed, my lord.
Yes.
I have filed an application under section 9. But my lord, this the London court below, my lord, the London judge family court, my lord, order visiting terms to the child. When I visited, as per order of this under annexure 1, when I visited to see my son, my lord, thereafter she created story and all of this, and my lord.
What is the offense?
Offense, my lord, 498, 294, 506, and 50. Only to not to carry out the order of the London judge family court, my lord, she lost the FIR. By making out some allegation that ମୁଁ ଯାଇଥିଲି ସେ ସ୍କୁଲ କୁ ସେଠି ସେ ସ୍କୁଲ ଅଥରିଟି କି ଯାଇକି ସେ ଛୁଆକୁ ଦେଖେଇ ଦେଲେନି କି ନା ଦିଶି ଦିଆନି
Allegations are allegation, what to do?
But your lordship kindly see, it is totally false case, man. Totally. Because on the graph of my lord 498, this case, my lord, initiated by the wife. Your lordship kindly see, since 2015, my lord, there is no, my lord, FIR or there is any 498 case. She filed an application for divorce. The London judge family court, my lord, pass order visiting term to the child, my lord. I visited as per.
What happened to the divorce petition?
That is pending, my lord. Both the cases are pending, my lord. In the divorce petition, my lord, the order was there, my lord, on my application to see the child, my lord. The court, the London court.
Charge sheet is filed, no?
No, my lord, on the very threshold, my lord, I am filing because it is totally a false case, my lord.
You will go and tell the police, they will file closure reports.
My lord.
Why are you at this stage?
My lord, so far 498, your lordship also know, my lord, and the Honorable Supreme Court.
I know, very unfortunate, but what to do? See, there are allegations, you have threatened the school authority, inform her and denied him to take.
But there is no such, your lordship.
Very unfortunate that the child is a victim.
Total, the informant did not allow me to see my child, my lord. And it is, I am the rightful, my lord. As a father, my lord, I am the.
Let us issue notice, let us see what can be done. Issue notice to the opposite party. Returnable within 2 weeks. Let us see if she comes.
My lord.
The problem is because of your fight, you are making that child instrument for your fighting.
Yes, my lord. That is the.
You are going to the school, creating problem for that child.
And my lord, she is a working lady. My lord, totally, my lord, neglecting the son.
It is because of your ego and your wife's ego. The life of the child.
Now the child suffer, my lord. Because of this scenario, my lord, now the child is.
You are also not less.
No, my lord, I am also not a good person, my lord. Because of this, my lord, so far as my son is concerned, my lord. I am, my lord, saying that I am admitting that I am not a good person.
Let her come, we will see, we will persuade.
Yes, my lord. My interim application may kindly be noticed, my lord. That
interim application.
There is no
FIR.
My lord.
In FIR, I will say FIR.
No, it is lie over, my lord, I say. I am.
Oh, that is there.
Yes,
And 498 you will get, there is no threat of arrest also.
No, my lord, there is no threat
Who
of
is going
arrest.
to
I have applied the.
Now the court and the police, everybody knows this kind of FIRs are false.
My lord, that is my lord now.
Later come.
Yes, my lord. IAB notice, my lord. That's my.
IA, what are you asking in IA?
I'm still further proceeding, but your lordship.
Where is the proceeding?
My lord, I bow down, my lord. Can notice.
No, no.
Okay.
49.
My lordship.
Take the date and file the
Yes, my lord, immediately.
requisites immediately.
Yes, my lord.
Make
By
sure
tomorrow-
that she should come
by
here.
tomorrow I will
We
come.
will see if it can be settled. Yes.
May Bill Lordship. The petitioner challenges the order.
Expeditious disposal.
My lord, the proceeding, I challenge the order, running page 14.
Now prayer, your prayer is
to quash the
Annexure 1 to direct the expeditious disposal of.
or to expeditious hearing. Swami file kala 144. Seta dispose जाएगी district judge कले district judge reject हैला civil suit file कर जंदी उनका 3S file कर जी 47 147 47 भाई के हम बिल्कुल केस किसी हो ना ये order से गिरे किसी गोटे proceeding सब ने दौड़ फेरी क्या
147 रे कौन हो
ତେଣୁ ସେଟା କଣ ଏଥର ସିଭିଲ ସୁଟ୍ ଚାଲିଲାଣି ସେଠି ଷ୍ଟାଟସ୍ କୋ ଅର୍ଡର ହେଇଗଲାଣି ସେଇ ଜମି ଉପରେ ପାର୍ଟିସନ ଫାଇଲ କରିଛନ୍ତି ସେ ଆନେକ୍ସ ଦି ଅର୍ଡର ଏଣ୍ଟାୟାର ଅର୍ଡର ଆଣ୍ଡ ଦି ସିଭିଲ ସୁଟ୍ ପ୍ରୋସିଡିଂ ପ୍ଲେଣ୍ଟ କପି ବି ଫାଇଲ କରିଛି ସେ କାଇଁ 144 ସେଠି କରିଛି ଆମେ ଯେତେ କହିଲୁ ସେ କିଛି କରୁନାହାନ୍ତି ସଦାବେଳେ ଦୌଡ଼ି ଆସୁଛୁ
When was the 147 process was start? In 20 seconds. 17
17 August 2022. Page 14. Running page 14.
What is the next date now?
My lord.
Next date?
Next date is 9/2. 9/2 के अच्छे. बस हारून नाते कि तको कुछ ही के action नहीं.
Yes, Mr. Maharaj.
स्वामी को अलग बोलता पुलिस तेरे
private party हमको copy देना.
No, but 147 state is there.
ना state नहीं.
किसी दे ना दिया अपन.
ना state तो ना.
এটা কোন কোথায় আছে 147
147 सर्विसेज थी भाई एडीसी भी कोर्ट में चली
हां हां एडीसी
या प्राइवेट पार्टी सिविल डिस्प्यूट चली
ताका नोटिस टा जाओ तो
नोटिस करी देखियो
नोटिस कर दियो तो
ऑपोजिट पार्टी यस नेक्स्ट 50
Lordship, item 50 kindly taken up next week.
Urgent. Yes.
51. 100 break to take up next week.
Urgent.
52.
51.
My lord, on behalf of Tapas Kumar Raja, kindly urgent.
Urgent.
Sector 1.
53.
53.
Lordship, on behalf of Mr. Chan, Lordship, praying for short urgent.
54.
Deep level.
Why everybody is running out?
Out of this.
Because of timing.
No, Lordship.
Yes. 54.
54.
Because of the function. 55.
55.
54 टा 54
Urgent, nobody is coming. What to do? Urgent.
56.
56 may please. Say application under section 482 CRPC for quashing of the criminal the cognizance order and process issued to the petitioner. My lord,
yes.
My lord, here, of course, my lord, before making the submission, I must keep it safe first. My lord,
Must say that I don't have a case.
No. My lord, I'll try to satisfy your lordship. My lord, I am very much conscious about the judgment of the Honorable Apex Court rendered in P. Dharmaraj's case, my lord. Where these type of offences, the Honorable Apex Court has strictly said cannot be quashed. My lord, even though there is a compromise.
Right.
My lord, here, but I am in a different footing in the sense, my lord. I am not the principal accused who has taken the money for the purpose of giving the employment, my lord. My lord, I am the person, as per the statements of different witnesses, my lord, which I have also enclosed, my lord. I am a person who was present at the time of discussion while the main accused person, he committed to provide appointment to the persons by taking money, and he issued all the forged documents to the persons who are claiming to the.
You help them.
But the allegation, so far as I am concerned, is, my lord, the allegation is that I was present at the time of discussion, and I somewhat statement I gave.
34.
charge sheet copy darkar.
Charge sheet copy I am having, my lord. I am
You have
having
not filed.
charge sheet copy.
Have you filed?
No, mu file karni.
File,
Charge sheet
file.
copy, but I have got the certified copy.
Mr. Mishra seeks time to file the copy of charge sheet. Same may be done within a week's time, at least after 1 week.
And also there is another problem, my lord. In place of annexure 5, my lord, another affidavit has been inserted in place of the affidavit which I wanted to insert, my lord.
Because you want to make
informant's affidavit.
You want to make the petition thicker.
No, my lord, I want to, my lord, file that affidavit also along with this charge sheet, because of
you want to file some other document.
Other document.
Charge sheet and other
document. Lordship may call it next week.
Not next week, next week. Huh?
16. What
16.
date?
16. Yes.
My lord. My lord, FIR was registered under section 363, 365, my lord. And this petitioner is the cousin brother of the principal accused. Lordship may see the judgment annexure 2.
Yes.
Judgment, it has been quashed because Lordship may see page 13.
30.
13.
Yes, 13.
The last Lordship may page 15. In view of the above discussion, it found that the victim has not whispered a single word about the alleged rape or kidnapping by the accused.
Where are you reading?
Page 15, paragraph 7.
Okay, 15.
Oh.
Para 7, yes.
Para 7. In view of the above discussion, it is found that the victim has not whispered a single word about the alleged rape or kidnapping by the accused. Principal. So, he has not corroborated the contents of the affair, and thereby he has not suppressed the.
And how do you know that this same witness will be not saying anything about you?
Yes, I have got a certified copy. That we have.
You have absconded?
My lord, she kidnapped kala bahala. Mu tar bhai ta podili.
You are the brother of the boy.
Boy.
Yes, exactly.
And they both
bhai, dada po bhai.
and they both are staying happily.
Happy, how? Lordship, I see that. And NBW has been issued on 27.
You are against the NBW or quashing?
Quashing, Lordship. Notice gale semanku nei asi kole deba.
Oh,
gote 10 ବର୍ଷ ରେ.
ଆଣନ୍ତୁ କେବେ କାଲି ପରଦିନ ମଣ୍ଡେ ଯୋଉଦିନ ନେଇକି ଆଇବେ ଯେତିକି ଜଲ୍ଦି ନେଇ ଆଇବେ ଭଲ ଆପଣ ପାଇଁ।
ଇନଫର୍ମାଣ୍ଟ ଭିକ୍ଟିମ ଦି ଜଣ ଗଣି?
ହଁ।
ଦି ଜଣ ଗଣି?
ନେଇ ଆସନ୍ତୁ ଫଟାଫଟ କରିଦବା। ମଣ୍ଡେ ଟ୍ୟୁଜଡେ।
ଟିକେ ସାର୍ ଟିକେ ଟାଇମ୍।
କୁହନ୍ତୁ ଆପଣ କୁହନ୍ତୁ ଆପଣଙ୍କ ଉପରେ ଡିପେଣ୍ଡ କରୁଛି।
ଆପଣଙ୍କୁ ଆଭେଲେବୁଲ ଯୋଉ ଡେଟ୍।
ହଁ ଫେବୃଆରୀ ଦେଖୁଛି ପା। 9 ତାରିଖ ସାର୍।
ହାଁ?
9
ହଁ 9
ଷ୍ଟେ ଅଫ୍ NBW।
NBW ନାଇଁ ଷ୍ଟେ କଲେ ଆପଣ ଆସିବେନି।
ନାଇଁ ଡେଫିନେଟ
ନା କଲେ ଆପଣ ଜୁନିୟରକୁ ପଠେଇବେ କହିବେ ଟାଇମ୍।
No, my lord. I am actually before the lordship because
ଷ୍ଟେ କରିଦେଲେ ଯାହା ପ୍ରୋବ୍ଲେମ।
No, not at all.
ମ୍ୟାଟ୍ରିକ ଖତମ କରିଦବା କଣ
ଟିକେ ଦରକାର ଅଛି। NBW ଟା ସେ ପ୍ରୋବ୍ଲେମ କରୁଛି। For that day, 9 ତାରିଖ ଯାଏଁ ଦିଅନ୍ତୁ ମତେ।
Then I will have to pass an order then. Yes. The petitioner has challenged the order dated.
FIR letter. FIR. I am challenging the FIR.
Petitioner has invoked the writ jurisdiction of this court. Inherent jurisdiction of the court under 482 CRPC, seeking quashing of the FIR in GR case number so and so. The counsel for the petitioner submits that insofar as the co-accused persons are concerned, they face the trial. And the trial, the court of additional CJM, Assistant Sessions Judge Rahul Kala, by its order dated 29/4/2023 in JO, what is this case? And T case number.
ST case number 131.
ST case number 131 so and so has recorded an acquittal in their favor and acquittal servers. It is he has pointed out para 7 of the said judgment, which reads as under para 7. And the counsel for the petitioner further submits that the victim girl has already married with the main accused, namely Prabhat Kumar Pradhan. And they are happily
Leading their conjugal life.
they are happily
and blessed with a son.
They are happily married and blessed with a son.
Yes, that is in
And
judgment.
the present petitioner is the cousin brother of the main accused. Cousin brother of main accused. Full stop. Then counsel for the petitioner submits that he would be the informant would appear before the informant, and the petitioner would appear before the court and next date of hearing for the purpose of appearing before next date of hearing. Okay. Reach the matter on 9th. Next paragraph in I लिखो.
Victim and informant.
Victim and informant.
Victim and informant. Victim and opposite party number 2 ना victim and informant. ठीक है. And I लिख दो till the next date of hearing, the operation of the NBW issued by the court below on issue को दे.
12th September 2023.
12th
Bar no,
Bar no, 2023. Till next date of hearing. 61 na? Parties are waiting na? Oh, sorry. Whenever the party comes and at 2 o'clock, you call them. So that why unnecessary waiting, no?
60 times on it.
61.
60 and the
61 60 next to mine.
60 next to
61.
Rushing of criminal proceeding in view of the compromise between the
what is the offense?
offense under section 341, 323, 324, 506.
Yes, the petitioner, who is the opposite party number 2 here? Opposite party,
Okay, number 2, my lord.
with number Kamalakant.
Kamalakant.
ये बाकी के गौतम कौन गौतमा
Patnaik.
नहीं 1 petitioner 1
compromise.
Gautama
Not
Susanto
Sushant.
Nishikanto Gautama is not coming. Why?
He's suffering violent fever.
Just now he suffered or really?
No, 2 days.
You have a luxury of accused having a luxury of not coming to the court. All of us are
That
working.
is fixed. He is ready to.
Don't encourage this kind of accused.
No.
They should come to the court. At least the
Sorry.
process is the punishment. That is why he has to suffer the process. Even for causing, he has to be there. Anyway, the petitioner
affidavit also filed.
petitioners have filed the present petition seeking quashing up for the criminal prosecution and the cognizance order. Cognizance order dated 22/5 April. Full stop. The land counsel for the petitioner submits that the parties have settled their dispute. The notice was issued to opposite party number 2. Mr. So-and-so entered appearance on behalf of opposite party number 2 and reiterates and submits that indeed the parties have settled their dispute. Petition number 2 and 3. Petition number 2, 3 and opposite party number two are present in the court. They are being identified by their respective counsel. They filed their photocopy of their self-attested photocopy of their Aadhaar card, which is taken on record. Mr. Maharaj, appearing for the state, submits that since the parties have now settled the dispute, and in view of the fact that the allegations are not serious in nature, there is no legal impediment in quashing the proceeding. Taking into consideration the aforementioned facts and circumstances and submission made at the bar, the so and so is quashed.
से साइन करिवे सर माने साइन करिवे
Sign करके देखिए. Next.
AD was not back. Tracking report is there. Compromise matter. Your lordship keep it to on 20th.
20th.
Yes.
20th. Huh?
Along with criminal miscase number 3878.
What is that?
That is counter case. Both are compromised.
Along with
CRLMC 3878 of 23.
Yeah. Okay.
62.
62
Next.
62. 62 ta कहलु. Oh, sorry.
62 रे your
59 on 20th your lordship.
62 na.
Fix it 20th all will left.
It is a case, my lord.
Yeah,
Last occasion.
you are on 59.
I am on 59.
Yes.
Can it be tomorrow, my lord? Tomorrow.
What is its matter?
That is your lordship heard earlier. I am the victim in this case, but I have been implicated because I have purchased a property which is subject matter of dispute in a civil court prior to institution of this suit, this affair. Allegation in the affair is that I have purchased this property from a person who was procured the power of attorney from a fictitious person. But the informant is not involved in the power of attorney. I am the subsequent purchaser. I am in the company.
Issue notice?
No, notice was issued, the complainant didn't appear. Notice was made sufficient. Last occasion, your lordship directed me to provide the written note of submission along with judgment. Today morning, I have given, let my land friend go through it. Tomorrow, your lordship comes. Tomorrow or next day, next.
After next week.
Your lordship preaches that he is having 18 cases.
Only.
That is not the matter. 18 cases, I can explain on what circumstances I have been involved. I purchased a property, royalty land. Now, subsequently,
what is your profession?
My profession, I am a builder, my lord. There is a company. No, there is a company. Your lordship, I can establish. Those cases have been stayed by this honorable court. Because
we'll examine next week.
Yes. All these 18 cases, that property dispute, but they claim that the property belongs to Lord Jagannath. 1929 was a record of right.
You have not, that means you have not spared Jagannath also.
No, it is not a Jagannath temple property, my lord. I have purchased this property.
We'll see what.
Yes,
next week.
Any date, your lordship.
Next week, take the time. Judge, I am hearing query period.
22nd.
22nd, let it be 20.
No problem.
एमिति हवा कौन फायदा?
Sir, move on. ठीक है. I am protected by the police. Police has released me on 41.
And you in any case, this is a part profession. 18 case, how does it make difference?